weekly list for orders item number 1.
In this matter, what has happened, since in a connected writ petition, an SLP has been filed, your lordships have fixed the matter to 15th July. Today it has come saying that on OP number 3 notice is not sufficient, but he has not claimed. It's not that he has a correct address was not there. And I found out the address given is correct. Either your lordship may permit me to take steps under Order 5 Rule 20 or treat him as sufficient.
See, also this is listed because Supreme Court has now said all these should be disposed of within 6 months.
That's correct. I don't stand up. I say simple matter, only arbitrators will be appointed, but then somehow complications arose. Let's make call it on the date fixed. This OP number 3 is concerned, the notice need not go again. Because it was, he has already.
No, but who is the contesting party? Is he a contesting party?
States, central government.
No, why have you implemented all?
I have implemented him because the salt commissioner has negotiated with him and saying that he has got also a share. So whether he has
But
got,
that's not the
that's not the issue to be decided.
he will not be party to the arbitration.
Not necessarily.
So what is your objection? Let's hear it today itself.
Your Lordship, I am for the Union of India.
Ah.
Your Lordship, arbiter can be appointed for resolving the dispute because so many factual aspects are there. So upon the arbitrary, Your Lordship, if passes an order, then we will be okay.
Okay, that's right. All right. You say as far as opposite party number 3 is concerned, Mr. Rao, learned counsel for the petitioner, points out that he may not be a party to the arbitral dispute itself. And therefore, service of notice on him is not mandatory. Paragraph. As regards the main dispute, the contesting party is the Union of India. And they do not have any objection to the appointment of an arbitrator to resolve the disputes between the parties. In that view of the matter, with the consent of the parties, what is your claim?
Nearly 3 crores will be there.
Justice Pramath Patnaik?
Okay.
This court appoints Justice Pramath Patnaik as sole arbitrator to adjudicate the disputes between the parties, including their claims and counterclaims. The arbitration will take place under the aegis of the Arbitration Center of the High Court. One.
Weekly list item number 2.
The lordships may see the last order. The SLP is still pending and there is a stay order on the earlier judgment which was passed appointing the arbitrator.
Okay.
Your lordships may keep it to sometime in maybe August or September so that if in the meantime any development in the Supreme Court happens, we can apprise your lordships.
The court is informed that the specially petition filed by the National Projects Construction Limited against the orders dated 30th November 2018 and 8th February 2019 appointing the arbitrator
Appointing.
is stayed. But why should the matter be kept pending? I'm not understanding. If the appointment has already happened.
Happened and then only the substitution because of the like appointment of this honorable nominated arbitrator having been nominated as the Lokpal member. So substitute arbitrator was to be appointed. But they challenged the earlier order, the initial appointment itself. So that is why.
So the application has not been able to be taken up.
Yes.
So what is this? It's in that missed case. You have to say missed case number 16 of 2019. Since the Supreme Court has stayed the aforementioned 2 orders, the present application seeking substitution of the arbitrator is unable to be taken up.
Okay, that's all.
List on. August. Correct.
Weekly list item number 3.
That's item number 3 as per last order was to be on.
No, you lordship can see the order dated 11th of March. No,
It's declined.
Learned counsel for the petitioner submitted that there has been some negotiations between the parties because I am appearing for the opposite party number 1. And the matter has been fixed to 8th of July. Wrongly it has been listed today.
No, actually, they listed all matters which had been pending for more than 6 months because the Supreme Court judgment said it should all be completed within 6 months.
The negotiations are going on for settlement out of.
Where is it, Mr. Malik? He's not here today. Mr. D.P. Malik, learned counsel, none appears to the petitioner. You are not aware of any such settlement or negotiation?
So that is going on. Today morning, I have contacted my officers. They said that it is developed to a little extent.
Mr. Mudali, learned counsel for the opposite party number 1, states that there is some progress in the negotiations. List on 8 July to 2022, the date already fixed. All right.
Weekly list item number 4.
All these matters,
We
are in fact in the final stage of settlement.
I see.
So we suggested one amount to them.
Okay.
They have rather requested to revise that amount and complete final.
All right.
So yesterday I had taken instruction, my lord.
So
we are maybe, my lord, shortly it will be settled.
So can we call it on 8 July?
Yes, my lord. I'll rather exercise my office to see that it is.
All right. Both counsel for both parties states that
Or your lordship, my advocate take instruction, these matters can be disposed of, if the outcome doesn't come away, giving a liberty to them to approach your lordship again, can be done also.
So now the amount has been quantified by them. We have suggested for some more. Let's have a decision on that, my lord. Then we will come to your
all
lordship.
right. At the request of counsel, the parties who state that they are close to finalizing the settlement amount. List on 8 July. All right.
This goes up to 8, man, item number 8.
Yes, up to 8. Okay. All right.
Weekly list item number 9.
Please, my lords.
Yes, please.
My lords, I believe there is a defect regarding the advocate's form name not being mentioned. That needs to be cured, I believe, my lords. Defect number 5E. If my lord may give me time till Monday, I'll cure it. If not, my lord may hear the matter out because it's an insurance policy. It was under an insurance policy. Our claim was rejected. We had come in writ petition before this court. The
Notice has not gone yet.
Sorry, my lords.
Notice is not gone yet in
No.
the petition. All right. Subject to removal of the defect pointed out by the registry within 1 week. Notice be issued, returnable
I know,
5th August.
I know.
Weekly list for admission item number 10.
Item number 10, my lords. Your lordships were previously pleased to adjourn this matter signed as the question of law is pending before the apex court, my lords.
But they're now insisting that it shall be disposed of within 6 months. That's the only problem.
My lords, actually the question in this petition is whether a agreement which has not been registered under the stamp duty, registered and stamp duty paid under the Stamp Duty Act, if an arbitration clause existing in that
I know.
agreement can be enforced. Which is
And there's a conflict of views.
my lords. It had been upheld by a 3-judge bench of
Correct,
the
correct.
Supreme Court, my lords.
So this was there, the lawyer from Nagpur was appearing,
My lords.
Mr. Arun Agarwal. The matter has been listed today in view of the judgment dated 19th May 2022 of the Supreme Court of India in SLP Civil 5306 of 2022 bracket Messrs. Sri Vishnu Constructions versus the Engineer-in-Chief, Military Engineering Service, requiring all applications under Section 11 bracket 5 and 11 bracket 6 of the Arbitration Conciliation Act 1996 to be disposed of within a period of 6 months. From that date. Full stop. Paragraph. However, in the present case, the issue involved is pending consideration in the Supreme Court of India. As noted by this court in its order dated 5th March 2021, before a larger bench of the Supreme Court of India. It is for this reason that the petition had been adjourned, awaiting the decision in the said case, a decision of the Supreme Court in the said case. Paragraph. List on. Second September.
Weekly list item 11.
11, your lordship, see the order dated 26 to 21, order number 8 and order dated 26 to 21. Lords, similar clause, in similar clause, lords, this honorable court has appointed arbitrator that has been challenged for the SLP Millard, that has been stayed Millard. So therefore, your lordship, see, lordship directed to the parties are liberty to mention this petition.
Correct.
For listing
You say
after.
again, this petition has been listed in view of the judgment of the Supreme Court dated so and so. As noted by this court in its order dated 26 February 2021. An earlier, no, you say an earlier order of this court appointing an arbitrator in similar circumstances has been stayed by the Supreme Court of India in SLP Civil 29310 of 2019, bracket Mahanadi Coalfields versus AP Construction. And it is for this reason that on 26 February 2021, the petition was adjourned sine die with liberty to the parties to mention it for listing after the disposal of the aforementioned SLP. That gives the matter list on same 2nd September. 2nd September.
Weekly list item 12.
12, my lord, I am for the opposite party. The case was earlier dismissed, and by order dated 6/5/22, your lordship directed the matter, restored the matter and directed the matter to be listed on 8 July 22. I am for the opposite party, my lord.
Yes. All right. So list on 8 July, the date already mentioned. All right.
As your lordship.
No, are you ready? If you're ready, then we can hear it today.
No. On behalf of K. Guru. Correct. Take a number next. Passover matter.
Passover.
The lordship may call it on 8 July. That's it.
All right. List on 8 July. All right. The date
Next.
already fixed.
Weekly list item number 13.
I appear for the opposite party. Lord. I will.
Petition. What's the date already given here?
The agreement was sent to your lordship to the FSL laboratory.
It is listed for today only. You're for the petitioner.
I am the opposite party.
My lord, you're for the petitioner. Oh, carry on.
Your lordship had sent the agreement for signature comparison. That is in the sealed cover, my lord.
It's a receipt. Yeah. Yes, please. Bad news, sir, for you. My lord, the petitioner, it says it's forged. Actually, your client has now invited 340 proceedings. This is prima facie material to initiate proceedings under 340 CRPC.
But I have filed an application of lordship. Connected records have come. Here also my signature has been forced before this honorable court also before the first.
Anyway, those proceedings are not before us. I can only deal with this. You say a report has been received from the examiner of question documents, CID Crime Branch, Orissa, Rasulgarh, Bhubaneswar, rendering the opinion that the disputed signatures, bracket X1 to X7, are forged signatures and have been produced by some electronic process. Copy of the entire report be made available to counsel for the petitioner on his by the registry within 2 days. The report be kept back in a sealed cover with the registry. Paragraph: in the view of the above report, the present application is dismissed with costs of rupees 25,000, which shall be paid by the petitioner to the opposite party within 4 weeks. Paragraph: in view of the seriousness of the misconduct of the petitioner in placing before the court a forged document on the basis of which relief has been sought to be, the Registrar General of the court is directed to drop a case for initiation of proceedings under section 340 CRPC against the petitioner. With the report of the SFSL forming the prima facie material for such proceedings. A copy of this order be sent to the Registrar General forthwith. For the purposes of drawing up the case and sending a copy of the report, the seal cover may be opened by the Registrar General and resealed after the case is drawn up and sent to the magistrate concerned. Right.
I may also be given a copy of that.
A copy of the report being made available both to counsel for the petitioner as well as the opposite party. All right.
Weekly list item number 14.
See, in this case, initially arbitrator was appointed, award was passed. That was challenged by me for last order. Last order, in your lordship, I kindly say that remit order that was challenged by my opponent Nalco, that is pending. Your lordship last occasion observed that after disposal of that arbitration appeal, this section 11 will be considered.
Correct. Because we have to list all these matters only because the Supreme Court order saying everything should be disposed of within 6 months. The first paragraph, you say the present petition has been listed in view of the order dated so and so the Supreme Court of India. As far as the present case is concerned, it was adjourned awaiting the decision of this court in arbitration appeal number 57 of 2018. I think in that appeal, you file an application giving a reference to the Supreme Court order and saying that because the appeal is pending, this.
I have already appeared in this appeal, but memo has not been filed, so it cannot be listed.
It had come before the vacation. I think within a month it will be heard. So
all right.
And they are
parties are requested to apprise the court before which the arbitration appeal is pending of the aforementioned order of the Supreme Court and request for an early disposal of the appeal. List on 2nd September. All right.
Weekly list item number 15.
Please, my lord.
It's coming up on 22nd July. If you're ready, we can hear it today.
Ready, but my learned senior would say whether he's ready or not. My lord, I'm ready.
Let's say next week.
That day, is it? We'll take it up on 22nd.
Yes.
All right. List on 22nd July, the date already. All right.
Weekly list item 16.
Lords, within item 16, my lords, 11 is the same order in 11 has to be passed. as the issue is pending consideration before the apex court, honorable apex court, and the last order, my lords, may be seen. This petition is still pending, my lords.
All right.
Same as 11, my lord. Same as 11.
11. Same order.
Number 11, my lords.
All right. Same order.
Sub item ARDT 5 also same.
All right.
And item 21 is also similar to item 11.
Okay. 21 also same order.
Much obliged, my lords, much obliged.
Right.
Weekly list item 17.
17, my lord, your lordship may kindly see the last order. I am on BC, my lord. Because of
Right.
the elements, your lordship may kindly see the last order. Last order is that awaiting the judgment of the constitutional bench of the Honorable Supreme Court.
Correct.
Of that stamp act. And in view of the now the latest materials
All right.
be on 6 months. That's why, my lord, your lordship on the earlier 10, serial number 11, and now serial number 16.
Correct. Same order. List on 12th August, the date already fixed.
Obliged, my lord.
Obliged, your lordship.
Right.
Weekly list item 18.
My lord, both the parties have settled their disputes. So
Item 30, my
that was the matter. I will permitted to withdraw both the arbitration petition.
All right. Counsel
31 and
petitioner points
32.
out that the matters disputes have been settled within the parties. He accordingly prays for withdrawal of both these applications. They are disposed of as withdrawn. Right.
Weekly list item number 19.
The opposite party. Now, we have not disputed the amount. We have not disputed.
13, my lord. Madam, Mr. Dujasman instructed me to adjourn the matter because he is in Delhi to participate in arbitration proceeding. Madam, in connection with item 13, may I adjourn to next Friday?
Sorry, which item, sir? Which item?
My lord, item 5. I am very much in the meeting since 10:30. Due to technical defect, I could not participate when my matter is called.
Which item, sir? We are now called out item 19.
Madam, I am 13 member adjourn Mr. Sujat Singh in the Delhi to participate in the arbitration proceeding.
Sir, we are now dealing with item 19.
My lord, due to technical defect, I could not attend the meeting.
Sir, 19, this is not your case, sir. Which is the number of your case? Which is your case number?
6 of 19.
We are now dealing with arbitration petition 48 of 2020. Yes.
Out of total 18 crores, 17 crores, 99 lakhs.
You'll have to speak in your the mic, please, because I'm not clear.
Lord, the amount has not been disputed by the opposite party.
Okay.
And the claimant has now demanded rupees 18 crores, my lord. We have already paid 13 crores.
Right.
And your lordship has, in fact, in the last hearing, your lordship has added it to 22nd of July, my lord.
Right.
So I think, my lord, if your lordship grants me 3 months time, or your lordship grants me 1 month time, so that I can file a time frame within which the total amount will be.
Why don't you? This
till April, they have paid 13 crores 29 lakhs. We had demanded by our demand notice dated May 2020, 18 crores 49 lakhs. On order 5 crores is remaining. They're saying they'll pay it within 2 weeks, 2 months. Or should fix it and matter was to come on 22nd of July. If you agree with matter, so August would be fine. End of August.
Mr. Das states that in all probability, the balance amount will be paid to the opposite to the petitioner within 2 months' time. In that view of the matter, list on 9th September. The next date, 22nd July, stands cancelled. Correct.
Weekly list item 20.
My lord, I am on behalf of the petitioner, your lordship.
Right.
Your lord.
There's already a date of 22nd August.
Lordship, but it has been listed. But the opposite counsel that intentionally avoiding is not coming.
I know, but since it stood adjourned to 26th August. It's in Biswal. Last time you had sought an adjournment, that's why.
Lordship.
Okay, list on 26th August, none appears for the opposite party. List on 26th August 2022, the date already fixed. All right.
We can list item 22.
All right, list on 22nd July, none appears for the parties. List on 22nd July 2022, the date already fixed.
We can list item number 23.
My lords, I am for the opposite party, my lords.
All right. None appears for the petitioner. List on 8 July 2022, the date already fixed.
I'm obliged.
List item 24.
24, my lords, on behalf of Mr. Kanunga, I prefer a week's time, my lords. Next week also, if it is taken up, my lords, no.
Next week we'll go to 8 July.
My lords.
Okay, at the request of counsel of the petitioner. List on, that's for the petitioner, right?
Petitioner, ma'am.
List on 8 July.
Great.
Weekly list item number 25.
My lord, item 25, 26 and 27, your lordship last occasion directed to come on 27 and directed the opposite party to file the counter. But till today they have not appeared nor filed the counter.
All right.
My lord, I am for the opposite party, my lord. The conducting counsel, Mr. K.K. Samali is ill, so I may be allowed 2 weeks time to file the counter. And noting is there, matter stands adjourned to 22nd July.
Counsel for the opposite party assures that counter affidavit will be filed within 2 weeks. List on 22nd July, the date already fixed.
Weekly list item
Next to
up to 27.
Yeah, up to 27. Correct.
Weekly list item 28.
28, my lords, I am for the petitioner. Actually, on the last occasion, my lords has given, permitted me to file a rejoinder to
Right.
their counter.
Right.
Actually, it is not filed.
All right. Counsel states the rejoinder will be filed positively before the next date. List on 12th August 2022, the date already fixed.
Weekly list item 29.
May I please, your lordship. But I'm submitting a short date chart, your lordship, with regard to the matter. Lordship, may look at the arbitration clause, your lordship, which is clause 14, page
My
number
lord, I
89.
wait for a short passover.
Item number 29.
Passover. Oh, this is the last item of this list.
Yes.
Lordship, look at page number 89, your lordship.
What is your objection to the appointment of an arbitrator?
My lord, we have given a counter, my lord. My lord, I pray that my senior will argue, Mr. Gautam Misra will talk.
It's a straightforward case, your lordship. There's an arbitration agreement. There's a notice for arbitration, your lordship. The claim has been rejected and subsequently the petition for appointment has been filed, your lordship.
So the amount claimed is 50 lakhs, is it?
No, 97 lakhs, your lordship.
I see.
Approximately. All the facts and merits can be decided at the arbitration tribunal, your lordship. In fact,
My lord, let it come next week, my lord.
Counsel to the opposite parties in some difficulty today. List on 8 July.
lordship, may I pray 22nd, your lordship. 8th, I'm not available.
All right, 22nd July.
22nd.
All right.
My lord,
My lord, my senior
to list.
my lord, my senior is here, my lord.
Ah, what is the objection?
My lord, we item 13.
There's a short point here. We are saying that the claims are ex-facie time barred. If my lord would see page 130, their notice invoking arbitration under section 21, that itself would show that it's beyond the period of 3 years. Now we are relying on one judgment of the Supreme Court in Geo Miller, which says that if it is ex-facie time barred, then under 11 the court will decline.
Lordship, if I may be allowed, your lordship, to place.
Let me just show that Geo Miller's judgment. my lord.
Okay, he was starting. No, he started with a list of dates. So let him. Yeah.
So, lordship, if your lordship looks at page number 89, your lordship,
that is clause 14.
Yes.
That is the arbitration clause, your lordship.
Right.
All disputes or differences or any kind whatsoever arising out of or in connection with or concerning the contract other than the disputes or differences for which specific provisions for this settlement have been made in the contract shall be referred to by the parties hereto for decision by the sole arbitrator to be appointed hereinafter as mentioned. Lordship, basing on this, your lordship, if your lordship looks at clause 13, previous page number 88 is the clause for conciliation, your lordship.
Yes.
Lordship, basing on this, your lordship, now I'll invite my lordship to page number 128, your lordship. That is where my claim arose, your lordship, page number 128. Page number 128, your lordship, it is the minutes of the meeting between both the parties for mutual negotiation for resolution of the issue for modification of such and such, your lordship. If your lordship looks at, your lordship is at page 128, your lordship.
Yes, it is.
The last line, your lordship, in view of the above, the claims of the parties rejected after detailed discussion. Here, your lordship, the claims were rejected, subsequent to which an arbitration notice was issued. If your lordship looks at the very next page, page number.
Is this?
Sorry, your lordship.
This is the date.
The date is, your lordship, 23rd Feb 21, 2021. At the very bottom, your lordship.
So your notice is after that.
Yeah, my notice is just after that, your lordship. That is at page number 130. 130 is my arbitration notice, your lordship, or subsequently arbitration notice was issued. They did not accept it. In fact, they have replied stating that there is a clause for conciliation. So we should proceed for appointment of a conciliator, your lordship.
So there is also an arbitration clause.
Yes.
So
Lordship, if subsequently, your lordship, if your lordship looks at page number 134.
Yes.
In fact, in the date chart also I mentioned, your lordship, that is page number 134, that is dated 8/5/2021. It says there was a request which was made by the respondents for an appointment of a conciliator. Subsequently, we also agreed. The subsequent page is page number 138, your lordship, whereby we have the petitioners have agreed for a conciliation and they have rejected our claim. And then subsequently, we have approached this honorable court for appointment of an arbitrator, your lordship.
This judgment may be. Two 2020-14 SCC 643. We have also mentioned it in our counter.
Yes.
Now, here, this arose out of. I'll just briefly tell the facts, my lords. Section 11 was filed for the Rajasthan High Court. Section 11 was declined on the ground that it's hit by limitation. There, in that context, my lord may just see the relevant paragraphs. Paragraph 6. The High Court in the impugned judgment accepted the respondent's argument. The court found that the appellant had raised the final bill on 8/2/1983, but had not stated any explanation for why it failed to take any steps for immediately referring the dispute in 1983 to the chairman, Rajasthan State Electricity Board, as provided under the arbitration clause. Further, that the appellant could not be allowed to make such a request under 1996 Act, given that the contracts provide that the arbitrator was to be appointed under the 1940 Act. This is all reflected that the appellant had filed the arbitration applications merely as a gamble for pursuing a monetary claim against the respondent without the existence of a bona fide dispute. Thus, the High Court in the impugned judgment held that the appellant had failed to make out a case of hardship once. Then, my lords, may kindly see paragraph 12. Paragraph 12. In the present case, since notice, this is important, notice was served to the respondent in 2002, the provisions of the 1996 Act will be deemed to apply to the present arbitration applications filed by the appellant. However, it remains to be examined separately whether the aforesaid applications have been filed within the statutory limitation period. Then they have extracted the relevant provisions. Then para 14, they have discussed about section 43. And they have discussed about the period, my lords. That it is 3 years from the date on which the cause of action arises or the claim which is sought to be arbitrated first arises.
So they have discussed that 3 years is the period. And then, my lords, my lord may kindly see paragraph 20 at page 650 on the left hand side. And the most important paragraph would be para 21. If I may read para 21.
Yes.
Applying the aforementioned principles to the present case, we find ourselves in agreement with the finding of the High Court that the appellant's cause of action in respect of arbitration application number so and so relating to work orders dated 7/10/79 and 4/4/1980 arose on 8/2/1983, which is when the final bill handed over to the respondent became due. Now, next line, my lords, is very important. Mere correspondence by the appellant by way of writing letters, reminders to the respondent subsequent to this date would not extend the time limitation. Now, in this case, if my lord comes to the dates, so what is crucial is 3 years from the date the final bill was given. That is what they have categorically held in this. This is something which is very crucial, my lords.
But what do you say to this, that the minutes of the meeting is 23rd February 2021? So that gives a fresh cause of action, doesn't it?
The limitation period just 1 second. Just, my lords, in view of Geo Miller, it says that subsequent events are inconsequential. What is important on which is the date on which you give your final bill. That's why this line was very important. Para 21. The day you give your final bill, your time runs to start from that day, and that is arrested the day you give your section 21 notice.
So no. There is a minutes of a meeting. You see, there are negotiations happening.
Yes.
It's not that a final bill was given and then a notice is issued. In between, something happens. That's not.
Yes. So that my lord may see the final bill and the negotiations. That is ex facie barred by limitation. My lord may see section 1. Page 130.
No. If you sit down to negotiate, how can you turn around and say this is already time barred?
Now, my lord, kindly see that the subsequent negotiations would not arrest the cause of.
Would it not? So let that also be examined by the arbitrator whether that renders the claim time barred.
No, exactly. Now, my lord, if the negotiations would have happened within that initial period of 3 years, then it may be different. Now, my lord, may just one document at page 130.
All right.
Their notice invoking arbitration.
Yes.
Now it is dated 16/4/2021.
Yes.
Annexure 10 at page 130.
Right.
Now
this is after the negotiations failed.
No. This is after the negotiations failed, my lord.
Correct.
My lord may kindly just hear me out. Page 131.
Yes.
Now the name of the work is given, agreement number is given, date of start, my lord may see 28/7/2010. Stipulated date of completion is 4/7/2011. Actual date of completion is 6/10/2012. Now, on the next page, they start writing, my lords. That is at para 8, page 132, last paragraph.
Yes.
So their final bill is sometime in November 2013. Now, if Geo Miller is accepted, then 3 years, it ends in November 2016.
No, but you made a payment on 15th December 2017.
Yes, your lordship.
No, my lords may kindly see what they are saying is the day you give your final bill, from that it starts.
No. See, we can't just be oblivious to the subsequent developments. You yourself make a payment on 15th December 2017, which is after the 3-year period after the bill, final bill.
Exactly, your lordship.
No.
So what is the effect? I'm just saying, what is the effect of this payment? What is the effect of your negotiation?
In fact, we are not aware why this payment was made. Our dispute is also concerned to that only, your lordship. In fact, as my senior is stating, the limitation period should start from the date of rejection, your lordship. When was it rejected?
What the honorable,
as per their,
just in your favor only, answer. What the honorable Supreme Court says that if on prima facie it is shown that it is barred by limitation, then you thrash it out. If there are arguable points, then you leave it to the arbitrator.
Correct.
What we are trying to contend before your lordship is that this is ex facie.
No.
If your lordship is not agreeing with me, then my lord may leave it to the arbitrator. My consent may not be.
No, obviously not. You see, the plea for appointment of an arbitrator by the petitioner under section 11(6) of the Arbitration Conciliation Act 1996 arises of a works agreement dated 28 July 2010 entered into between the parties. The work was for modification of a dumpling platform for plying of 120T dumpers at the Bolani ore mines. Paragraph. Admittedly, clause 14 of the said works agreement provides for arbitration between the parties. Full stop. A serious objection is raised to the maintainability of the present application by the opposite parties on the ground of limitation. Full stop. It is stated that the final bill was submitted way back on 13th. What is the date of the final bill, you said?
As per their lordship, as per our the bill that we have received is 15/12/2017.
No.
A payment has been received.
No. Date of your final bill, please.
In the notice, it appears that it is November 2013. Because
that's only a request for release.
Yes, so final bill must have been prior to that. And what is crucial is the date of final bill, the date of submission. That's what Geo Miller says, but
it appears that a request was made for release of payment of a bill number 18 for rupees 50,51,365 on 13th March 2013, followed by another request on 6th November 2013. Stop. It is accordingly submitted that more than 3 years have elapsed since that date, and the notice for arbitration was issued only on 16th April 2021, which was plainly time barred. Reliance is placed on the decision of the Supreme Court of India in Geo Miller and Company Private Limited versus Chairman Rajasthan Vidyut Utpadan Nigam Limited, 2020 14 SEC 643. Mr. Gautam Mishra and its senior counsel for the opposite parties insist that events subsequent to the submission of a final bill will have no bearing on the fact that the claim already stands time barred. Stop. Paragraph. Counsel for the petitioner, on the other hand, has handed over a date chart which suggests that on 15th December 2017, the opposite party made a payment of rupees 20,37,388 to the petitioner by way of a bank transfer. Full stop. According to the petitioner, the parties also sat down for negotiating and has referred to the minutes of the meeting of 23rd February 2021. Also, it is submitted that after those negotiations failed, the petitioner issued the arbitration notice dated 16th April 2021, and therefore, full stop, it is submitted that on 4th August 2021, on 8th May 2021, the respondents requested for appointment of a conciliator, to which the petitioner agreed on 4th August 2021. Full stop. However, on 23rd August 2021, the respondent rejected the request for appointment of a conciliator. Paragraph. Although it is urged by Mr. Gautam Mishra that in the present case, the claims appear to be ex facie time barred, this court is unable to agree with the said submission. Full stop. It appears arguable whether, in fact, the claims were time barred when it is seen that the petitioner, when the opposite party on its own made payment of a substantial sum to the petitioner on 15th December 2017. Although this was beyond 3 months from the date of the final bill. Full stop. Again, the fact that the parties sat down to negotiate on 23rd February 2021 is unable to be denied by the petitioner, by the opposite party. Full stop. Both these events appear to indicate to the court that the contention of the petitioner that the claims are ex facie time barred cannot be straightaway inferred. Full stop. It appears to be an arguable issue. Full stop. In that view of the matter, leaving the issue of the limitation to be also decided by the arbitrator. The court appoints, so we'll have a senior lawyer, sir.
Lordship, if my senior agrees, may I suggest the name of Mr. Upendra Samal? If my senior is okay with it.
No, Mr. Samal, I think my lord may consider it's around 1 crore. My lord may consider a retired judge.
District judge.
My lord may have a district judge.
Retired judge, your lordship. Whoever
Retired
your lordship.
district judge or-
Retired district judge?
Retired High Court judge, your lordship. If
No,
not a
1
senior-
crore claim, I don't think.
It is 97 lakhs in fact. That's why I was suggesting a senior advocate as my senior is okay.
Let there be a senior lawyer.
Asinath Panigrahi, retired district judge, is also in the panel, and
Sorry, who?
Mr. K.N. Panigrahi.
K.N. Panigrahi, yeah. The court appoints Shri K.N. Panigrahi, a former district judge, as sole arbitrator to adjudicate the disputes between the parties, including the aforementioned, including the claims and counterclaims, and the aforementioned issue of limitation, full stop. The arbitration will take place under the aegis of the arbitration center.
There's only 2 things I wanted. My lord said that the court is unable to accept the contentions of the petitioner. That will be opposite party.
Of the opposite party. Okay, I'll make it.
That's one. And second is the arbitrator will not be influenced by any of the observations.
Yeah. None of the arbitrator will not be influenced by any of the observations made by this court in the present order.
We are all great.
Right.
Obviously.
In fact, there's hardly left anything to say at 11 after these. Limitation is just one new case has come. Otherwise,
all
right.
My lord, item 13 in a week list. The disputed document may be sent to further verification to Hyderabad at the cost of the petitioner.
That's already over, sir. That's already over. Right.
My lord, is junior director to able to do the matter when they reach, maybe pardon to mention again to the conducting council in Delhi to participate in the arbitration proceeding. Let the disputed document may be sent to Hyderabad at the cost of the petitioner for further verification.
No. We're not persuaded like that. All right.
Well, supplementary list.
Yes.
Supplementary list has admission item number 1.
Number 1, the annexure 1 is the agreement, and there is a clause of resolution of dispute by arbitration at clause 17, your lordship. It's a page 24. So notice is to go.
Notice returnable. 5th August.
Supplementary list for orders item number 2.
May I please listen? The bail application, the accused is in custody since 22/8/2020. Earlier, the 2 bail application has been written before this honorable court. For that is the reason it was listed before your lordships. The offense under section 399 and 402 read with 25/27 armed act.
2 applications have been withdrawn.
Yes, withdrawn.
And
But what I kindly see, annexure 3 series.
What is the stage of the case? Get the record to CD. Case diary. Case diary. I have to get the case diary.
The case diary.
Case diary is earlier application.
What's the stage of the case?
Now stage is trial is going on.
Trial is going on.
Yes. What happened? In the meantime, I have annexure 3, my lord.
Witnesses have been examined. The independent witnesses have been examined.
Because 399, so for the my instruction, the rejection order shows that 3 witness out of 12 witnesses, 3 witnesses already examined at the month of March. Now 3 to all total, my instruction is 5 to 6 witnesses have already. Nobody is stated. But kindly see.
1 minute. Have all of them turned hostile? Have all these 5 witnesses turned hostile?
Yes.
So let him take instructions on that.
I draw your attention. Kindly annexure 3, my lord. All have been released on the all the accused except this petitioner. So all have been
let him take instructions.
I have given all the copy, my lord.
Yes, in the orders. I don't have the records.
No,
Counsel for the petitioner contends that because of the record is the earlier petitioner record makes two submissions. One is that all the prosecution witnesses examined so far have not supported the case of the prosecution. The second is that all other accused except the present petitioner have been enlarged on bail. Mr. Katkia seeks time for instructions on both the above submissions. List on 15 July. 15 July, sir.
Coming Friday next Friday.
Coming Friday is a holiday, sir. Rath Yatra.
Fortunately.
All right, 15 July.
Supplemental list item number 3.
Item 3, actually, I may be allowed to present for Lordship. But here actually, if Lordship appointed the arbitrator in this case and directed him to examine with regard to the fraud that is there and also in other issues. The arbitrator actually, we appeared before the arbitrator and they raised the preliminary objection. But in spite of that, arbitrator did not take up the matter and say it's deferred till you file a contentious objection and all those things. That was the subject matter. I filed a writ application challenging the order of the arbitrator. But the question arises here already.
Actually, is a review petition maintainable at all?
So that the review application is maintainable.
How do you know?
For reason being, if Lordship finds there is some legal point actually that arises, which could not be brought to your Lordship notice at the relevant time, that can be brought to your Lordship notice. But I just intend to bring your Lordship the Vidya Rolia's case. I have referred to those judgments and also various other judgments relating to the subject matter. If your Lordship kindly see that judgment, page paragraph 224, that is relevant. So the judgment is a bulky one. I am supplying your Lordship. Yes, paragraph 224, if Lordship looks at.
Yes.
May I just read it, Malad?
Yes.
In MR MGF Land Limited, this Avtab Singh, this court held that this Consumer Protection Act cases are not arbitrable. On perusal of the judgment, no doubt reliance was placed on Booz Alliance case, and there is some discussion on the scope of Section 8 of the Arbitration Act. However, the thrust of the reasoning is not on question of arbitrability. Rather, it was the fact that Consumer Protection Act had an implied bar for referring a matter to arbitration, being a special legislation. The difference is subtle, yet it is required to be recognized that the Consumer Protection Act impliedly barred the application of Arbitration Act. But here actually...
but there was no arbitration clause, sir.
Yes. But here
the question was when the matter is going on before the consumer forum, can parties be referred to arbitration? That's a different issue.
But here actually question is the matter has already been adjudicated.
Yes.
The builder, the promoter had committed fraud on the buyer. But he had already taken the entire money, 13 lakhs some odd, who is a retired judicial officer, and he doesn't have any money. He says, no, I have cancelled the allotment. But arbitrarily has cancelled. Then he went to the consumer court. They filed an application that the arbitration clause is there, consumer proceeding cannot proceed. That was rejected. That was not challenged. Then the Consumer Protection Authority granted, passed the final order. That was, he challenged subsequent stage. Well, they are charging us the registration fee as 70,000, which valuation should be 9 lakhs. Now the valuation of the property has been shown to be more than 12 lakhs. But these are the matter. Actually, I filed an application, filed an FIR also. That is pending consideration. They are not taking any action because he is a very influential and powerful man.
All right. There's also a delay in filing this. What's the delay?
Delay, I have filed those before the arbitrator I filed application. From that period till the period actually the Honorable Court expressed, or in fact, when the matter was challenged for the Honorable High Court, I could expect unless you get that order reviewed before the Honorable Single Judge, we cannot.
What's the delay?
440 days.
440 days.
So that is actually pendency. Section 14 application is filed. because the matter was pending in different forum.
No, but what's the date of the writ petition order? 12th May.
Yes, but I have annexed that one.
All right.
Last order.
All right.
That page 191.
All right. You see, for the reason stated there in the delay in filing
Annex
the 138 of 2022, the delay in filing the review petition is condoned, the application is disposed of. And then the main review petition, IA number 139 2022, no grounds made out for recall of the order dated 5th February 2021. The review petition is dismissed, the application is also dismissed. Not in time, sir.
Supplementary list item number 4. Next, please, my lord. And my lord, this is a work with Mahanadi Coalfields, my lord. Here, my lord, the arbitration clause is at page 136. Past existing work and contract, my lord. Clause 5. My lord.
Oh, notice has not gone yet.
No, my
Mr. Devraj Mohanty was here somewhere. They've accepted
They have
notice.
a panel of lawyers actually.
All right. Notice returnable 5th August. That's right.
Another petitioner, similar petition, already notice has gone. I will give that number, my lord, so that both the matters can be tied.
There's no date given in that.
No, my lord. No date has been given. I'll verify and I'll.
All right.
Supplementary list item 5.
My please,
My lord is giving a date in
5th August.
my please, your lordship. Lord, page 14, clause 12 is the arbitration clause, your lordships. And your lordship, there is a pre-mediation litigation which has failed at page 53, your lordship. Thereafter, my lord, annexure 11, page 54, the notice for appointment of arbitrator was issued, but no appointment is made, your lordship.
Notice returnable 12th August.
supplementary list for admission item number 6.
Item 6, my lord, your lordship has sent it for mediation. In fact, the opposite party agreed to pay 5 lakhs, but they took time of January 2024. My friend agrees.
That has been settled on your lordship.
The report is there with my lordship. They agreed to pay an amount of rupees 5 lakhs, but in 7 installment, which
It's all right.
Come to an end.
If you've agreed, sir. You see, there's an agreement between the parties, which has been recorded in the report of the mediator, dated 21st June 2022, which is placed on record. They said settlement terms as indicated therein are placed on record. The parties are directed to abide by the terms of settlement. The petition is disposed in terms thereof.
and I have been, I have to pay the bank details. I'm submitting a recording. I have to give in the bank details as per the agreement. As per the agreement before the mediation.
That's it. You are anyway bound by those terms, sir.
That's my record. I am submitted.
All right. The bank details have been submitted by the petitioner to the opposite party.
Yes.
Right.
Supplementary list item number 7.
Item 9 for the petitioner, my lords.
Yes.
7, 8, and 9. We have appeared for the OP number 1.
Yes.
And OP number 2 is the formal because the arbitration tribunal has been made a party. I think
that's not necessary. Correct.
So we'll file a short reply to the application on the maintainability of it because they have also filed. This is under section 14 and 15 along with 11.
I see.
So we will file a short reply. Your lordship will grant me 3 weeks time.
All right. Mr. Nandal, appearing for opposite party number 1, seeks and is granted 4 weeks time to file a reply. Rejoinder for the next date. 26th August.
26th. Obliged.
Supplementary list item number 10.
Item 10, I have the opposite party. Last occasion, I set a time to take instruction, my lord. We have received the instruction. We want to file a affidavit. Let's give some time.
Yes, sir.
Because they are disputing that according to clause 25, the department arbitrator can be appointed. This is the clause which, but it is contradicted to the 11.6. They are consisting the 12.5.
Correct. Then might as well agree to arbitrator, sir.
I need assistance from my lord. That the allowed judgment may become, then it will be a precedent for all the cases. Then we will not be in the stand.
In fact, my learned friend on the
I'll file the detailed counter affidavit. My Lord may hear it and pass an order which will be help for all the cases because.
In fact, on
State
the
was
last
very
occasion,
problem,
my
my lord.
land friend in principle agreed that somebody independent arbitrator to be appointed.
Correct, correct.
And just wanted that he should take instructions. Couple of dates have passed.
All right,
my lord.
Mr. PK Padi prays for and is granted 4 weeks time to file a reply. Rejoined for the next day. 26th August.
26th August.
Obliged.
Supplementary list item 11. My lord, I'm sorry, but 26th August, I will not be there. Any date, this side or that side.
12th August. 12th August, sir.
Yes, my lord, yes.
12th August.
Lords may reflect along with Mr. D. Tripathi along with me, the Devashish Tripathi.
All right, all right.
Supplementary item 11. My lords, in this matter, the copy of the reply affidavit was served this Monday on 20th. What's if I'm praying for 2 weeks time to file the rejoinder in this matter?
All right, rejoinder be filed for the next date.
My lord, I just have one submission to make before my learned counsel seeks time for file rejoinder. Lord, although we can have no problem with appearing before your lordship, my lord, but there is a small jurisdictional issue in the matter. My lord, the petitioner ought to have approached the appropriate court under section 2(1)(e) of the act. And the petitioner has erroneously approached this honorable court. And my lord judgment in MG Mahante reinforces that position that as per section 14, application has to be made to the court under section 2, which is the court of principal civil jurisdiction in a district, which happens to be my lord's senior civil judge of Bhubaneswar, Orissa.
We'll file a reply to that, my lords.
All right. Rejoinder be filed for the next date, 5th August.
Lords.
Grateful, my lord.
All right.
What is the interim order may be continued?
Interim order to cut. All right.
Yes, sir. Special list for orders, item number 1.
This is it. None appears to dismiss the non-prosecution. The interim order is dictated. Copy of the order be communicated to the concerned court forthwith.
Special list item number 2.
May please, your lordship. Challenging the passing of FIR, my lord. If registered PS case number 251, 31 December 2021, corresponding to GR case number 1525, registered under section 420, my lord.
Sorry, section
420, my lord.
420.
Under section 420, my lord.
Yes.
I'm challenging the question of the FIR, my lord.
You're challenging the question of the FIR?
My lord.
I don't understand.
Praying for
the question.
I'm sorry, my lord.
You reserve all your pleas to urge before the court, sir, at the appropriate stage. You say reserving the pleas of the petitioner to raise all the pleas urged in the present petition at the appropriate stage. The petition is disposed of. Interim order is vacated. The order be communicated to the concerned court. Yes.
Special list item number 3.
My lord, I could not understand.
You can raise all these pleas, sir, at the appropriate stage.
Yeah. My lord, I am placing 3 judgment, my lord. It is civil in nature, my lord. I am placing 3 judgment of the Supreme Court and I'm submitting, my lord.
All right.
Yes, my lord. This is the matter, my lord. The agreement between the parties and they have the term was they will deposit certain amount in certain period and after maturity they will get the amount. Now they have deposited in the various occasions, my lord, 2,25,000 and it should be matured and they will get the 4 lakhs, my lord. Then after on basis of which when the payment was not made, the petition has the opposite party respondent number 2 has made a complaint, my lord, with the police, my lord, on basis of which the PS case is registered, my lord. In the PS case, when the PS case registered, the here, my lord, the company is not in party, my lord. Company is 7 Hills Private Estate Limited, my lord, is the company. His name is not there. It's not the party in the proceeding, my lord. So the Godfather cases 2012 high SEC CC1 is applicable here. And second, your lordship, the ingredient 420, my lord, I am submitting 3 judgments, my lord.
Who is appearing for opposite party number 2? The complainant. Has he been served? Opposite party number 2 has been served.
Sakutra Samatra, man.
Not steps not taken. So no steps have been taken for fresh notice.
I will take notice, my lord.
No, sir. No, sir. I'm not convinced about interfering at this stage.
No, but proceeding will matter. Because, my lord, the judgment is clear, my lord. This is a civil in nature and the money claim is there, my lord. So no criminal proceeding.
You have to settle these matters. You go before the trial court, you go for mediation to get settled. 420 is compoundable.
Your lords may direct a state court take the instruction. What is the status of the? Yes,
No.
I will take the fresh notice, my lord. So the matter shall be resolved, my lord, because the judgments are very clear, my lord.
Let it go back, there you will get it resolved. Yes. Yes.
Item number 3. Specialist item number 3.
The memo is taken in record. The petition is dismissed as withdrawn. The interim order is vacated.
Specialist item number 4.
Item 4 may see. In that case, the present person challenging the order of was passed by the JMFC 24 in Annex 3
What's the offense, sir?
Now the offense under has been registered under Annex 1 offense under section 1 under section 193, 201, 202, and 203 and 217, 218 of IPC.
Yes.
The cognizance once the cognizance has been taken against the Surendra Kumar Ball, which is Annex, which is the page number C and page number 19 cognizance is taken. But I am challenging the cognizance since the 21 to 13
Yes. This is a accident case, sir. 304A.
Yes,
You're not mentioning 304A, you're mentioning all other offenses.
See, 304A has been taken against the Surendra Kumar Ball.
Whatever. It's your car, right? Your company car.
The present petition is also the ASI.
All right. The present petitioner is an ASI.
My lordship.
ASI
my lordship. Page number my lordship.
You were traveling in that car, is it?
17.
You were traveling in that car.
No, my lordship. And that was I was investigating the case, my lordship.
I don't understand.
I was there. I was that case, my lordship.
So how are you agreeing?
Can you see the page number 4, my lordship? 6. Item 6 my lordship.
What was the offense against this man?
Let's. I'll just seek instructions, because case diary is not there.
Case with the order.
Is the owner.
Because he was giving shelter to him.
What is the case against him, sir? You are not clear.
Now, sir, I was investigating that case, my lordship.
Yes.
I have a page number 18. I have total evidence, my sir. I sketch 14, my lordship. I have examined and also examined after examination investigation. I have released the driver, my lordship, once you prepare ball, my lordship. Then the ball, my lordship, has taken cognizance against the accused person, my lordship.
Cognizance order.
You're not able to explain what the case against him is.
Order is also not annexed. Annexed.
No, the cognizance order alone is annexed.
All the accused persons. He is not.
Oh. You have to say question and satisfied. During the course of investigation, the present petitioner who was investigation he was transferred to the magistrate from Dharmasala to Chatai, another police station magistrate. And that case was handed over to another IAC magistrate.
Obviously, he's tried to cover up the accused. I think that's what the accusation is. The investigation to be transferred to the CDCID because of irregularities committed by you.
Some irregularities committed
Correct.
by IU.
Correct.
But the investigation, that is why the magistrate took cognizance.
Correct.
The final charge sheet has been submitted by the another police officer.
Correct. Because the investigation was transferred to that person. Let it be examined by the court below, sir. You say reserving the pleas of the petitioner raised in the present petition to be urged before the trial court at the appropriate stage. The petition is disposed of. The interim order is vacated. So, copy of the order be communicated to the court concerned forthwith.
Specialist item number 5.
5 minutes, please. 5 minutes. In that case, the present petition is challenging. There is a law and application between the present petition and opposition number 3. And they have solemnized their marriage ministry. Which is annexed to series ministry. And the opposite is the father of the opposite number 3. He has lost the FIR and FIR has been annexed to 1 under section 363 and 506 and 34 of IPC.
It's all right. Same order in this case. The interim order is vacated.
Already solemnized their marriage.
Where is that affidavit?
Affidavit is annexed to 2. Is the notary certificate with the 14 place number. Marriage certificate of silence.
That's it at page 14, Millers, that is the notarial certificate.
All right. We say there's an affidavit filed by opposite party number 3, confirming that she's married to petitioner of her own volition on 30th July 2014 itself. There is no opposition to the above affidavit by on the side of the police. That is the matter the court quashes the criminal proceedings against the petitioner in CT case number 408 of 2014, corresponding to Bhogarai PS case number 160 of 2014, pending the file of the JMFC Jaleshwar. The petition is disposed of. A copy is order to be sent to the concerned court.
Specialist for admission, item number 6.
May please your lordships, I am on virtual mode, my lords. Lords, this case arises, I am a SD Das on virtual mode, my lords.
Yes, yes.
Lords, this case arises out of a petitioner and opinion number 2 married to each other in 2001. There is some family dispute for which in 2003 a divorce petition was filed by the petitioner. As a counterblast to it, and a FIR was filed in 2003, my lords, under section 498A, challenging that I had approached your lordship. In the meantime, I have no instruction. Can I?
That's okay. No. So we're not adjourning it. You can urge all these pleas at the appropriate stage, permitting the petitioner to urge all the pleas raised in the present petition at the appropriate stage in the criminal proceedings.
If it survive, if in the meantime there might have been a compromise, my lords.
Maybe, whatever. The petition is disposed of, the interim order is vacated. Yes.
For admission, item number 7.
May it please, my lords. My lords, I am appealing through VC, my lords. In
Yes.
item 7.
Yes.
Pursuant to my lords, last order filed the memorandum of settlement by way of a memo today in the court. Will your lordship have it?
1 minute. No, we don't have the memorandum of settlement. Is it there?
Lords, it states that no dues are pending.
The counsel petitioner produces a letter issued by the Secretary, Sundargarh District Central Cooperative Bank Limited, Sundargarh, dated 6th July 2011, stating that there are no dues against ORIND Latikata with the said bank. What is ORIND? What has it to do with you, sir?
My lords, it was the association in which the petitioners were principal. My lords, he was the managing director and one was the manager finance. And the FIR, it was alleged that, my lords, that they had taken.
So this can be produced, sir. You produce this before the court concerned. So why don't you produce this before the court concerned and get the case closed? That's better.
Lords, the problem is the case was stayed, my lords, since long, my lord. And one of those petition number, my lords, one of the accused persons have already died since long in a similar case, my lords.
No,
So
because I don't know if opposite party number 2 has been served.
My lords, as per my lord's fresh notice, I had filed fresh requisites on the last occasion. If my lords may see the order dated 22nd of April 2022.
No, that notice has not been received back, sir. The notice to opposite party number 2 has not been received back.
Well, in that event, I have filed the memorandum of settlement, which clearly states that there is no due. And as such, Millets, the FIR will not stand against any of us in that event, being no dues as such.
So
The
you just
entire
have to get the statement recorded. You please apply for a discharge. That's it. You file this application along with this letter and apply for a discharge. That's the easiest way to do it, sir. Which of the two petitioners is not alive?
Millets, there were actually 4 or 5 petitioners in a multiple
there are
case
two
which was
petitioners.
registered.
There are 2 petitioners in this petition.
No, Millard, there are 2 petitioners, there are alive, Millard.
Ah.
There are other family
You say
members
it will
who
be
were
open to
also
the
indicted.
same statement. It will be open now to the petitioners to apply to the court below for discharge on the strength of the above letter. The petition is accordingly disposed of, the interim order is vacated. All right.
Let's in the meantime, may I pray until the discharge petition is heard, I may be interimly protected in the meantime.
Yeah. You said till such discharge application is filed, no coercive steps shall be taken against the petitioner. All right. Provided the discharge petition is filed not later than 22nd August 2022. Right.
Grateful, Millard.
Special list for admission, item number 8.
Item 8, my lord, I pray kindly permitted to withdraw, my lord.
Withdraw.
My lord.
Counsel petitioner seeks leave to withdraw this petition with liberty to urge all the pleas raised here before the court below at the appropriate stage.
Oh, bless my lord.
Disposed of is withdrawn with liberty is prayed for. The interim order is stands vacated. Right.
Special list, item number 9.
Item number 9, your lordship, no instructions. No instructions disposed of. The stay is vacated.
Special list, item number 10.
To the court below.
Item number 10, your lordship, we want to withdraw so that after framing of charges will
withdraw with
approach the
liberty
court.
to urge all the pleas. The interim order is vacated.
Special list, item 11.
May it please your lordship. My lord, this petition was filed for the quashing of the criminal proceeding pending before the learned court below your lordship. The allegation is the petitioner is under section 420 and 138 of NI Act. Here, your lordship, there is a transaction between the petitioner as well as the opposite party number, late brother of the opposite party number 2. And there is some money transaction was there. And unfortunately, the brother of the opposite party number 2 has died. On demand, on live threat, the opposite party number issued a 3 checks, your lordship. Petitioner issued a 3 checks. One check was clear.
For all these pleas, you can urge the appropriate states.
Now this
is not the stage for interference.
My lord, my humble submission, I may be I ready to compound the matter, and both the party already I have already written, I have mentioned in my application that petition is ready to give all the amount.
You make that plea before the trial court.
Till then, my lord, if to subside the matter, no course action. This is my
already you enjoyed all that for 10 years, sir.
No.
Now you can make that plea before the trial court. You say leaving it open to the petitioner to urge all pleas raised in the present petition at the appropriate stage of the trial court. The petition is disposed of. The interim order is vacated. Yes.
Special list, item 12.
None appears dismissed and non-prosecuted. The interim order is vacated.
Special list,
the order be communicated to the court below.
Special list, item number 13.
The memo for withdrawal is taken on record. Dismisses withdrawn. The interim order is vacated. Copy of the order be communicated to the court below forthwith.
Special list, item number 14.
I am appearing for the opposite party, my lord. Appearing for the petitioner, my lord. My lord, this is a case where a case initiated on the basis of a complaint case, my lord. The petitioner has sought for quashing of the cognizance order, that is at page number 28, my lord, wherein the cognizance has been taken against the present petitioners under section 294, 447, 448, 427, 354, 506, 323, 34 of IPC. My lord, all the present petitioners are government servants, my lord. My lord, the allegation as per the complaint case is that the that while the informant was at his house, the present petitioners came and outraged her modesty and demolished the house of the petitioner. My lord, these present petitioners are all the public servants, and petitioner number 1 is the Tahsildar. A civil suit was civil suit for the suit land that is in dispute here. The civil suit was decided against the informant. The additional civil judge junior division decided that the present informant has no title or possession of the property. After that, Tahsildar initiated a encroachment case. Encroachment case against the order of the additional civil judge junior division. The informant has preferred appeal. While the appeal was pending, in the encroachment case, the Tahsildar served a notice on the informant. After that, my lord, since the appeal was pending, the petitioner number 1, that is the Tahsildar, sought for a clarification from the government pleader. Sought a clarification from the government pleader that appeal is pending, but there is pressure from PWD department to construct a culvert on the said land, as that is a government land, my lord. The government pleader replied to the clarification letter of the, and the clarification is at Annexure 6, my lord, page number 33. The government pleader clarified that I do hereby clarify the points raised by you in the above referred letter, which was received by this office on 35/11. No stay order granted by the appellate court as required under Order 41 Rule 5 CPC in RFA number 14 of 2011. As per the law, an appeal shall not an appeal shall not operate as a stay of the proceedings under a decree or order appealed from, except so far as the appellate court may direct. As it appears from the record available in the office of the undersigned, there was no application submitted by the appellate in the appeal under Order 41 Rule 5 CPC, and hence there is no question of any stay order from the appellate court. As there was no stay, after getting this clarification, the Tahsildar wrote a letter to the subcollector Hindod, with the subject of deployment of police personnel to evict the encroacher from plot number so and so, the government plot. After that, the Tahsildar wrote another letter to the STPO Dhenkanar, that is at Annexure 8. Then he wrote another letter to the assistant engineer PWD.
So all these letters will be examined by the court below, sir.
My lord, the section 197 says that cognizance cannot be taken against the public servant without the sanction, my lord. To assist your lordship, my lord, I am submitting 2 judgments of the
where is the order taking cognizance?
My lord, that is
are all of them still in service?
My lord, I have no instruction regarding.
No, none of them is in service now, except 3. Maybe the others are not in service, except petition number 3.
Let the complaint petition and the initial statement will clearly make out a case under section 294, 354, 448, 447, 323, and 506 of IPC. Milord. Accused persons dragged the complainant, abused in obscene languages, outraged the modesty, undressed her. The specific allegation in the complaint petition, para 7, my lord. Suddenly, all of the accused persons conjointly dragged the complainant from her house, holding her trapped up hair, saris to hands, etc., and abused in obscene languages, my lord. And thereafter, accused persons used their criminal force and made naked and outraged her modesty. In the initial statement also, clearly make out the case under section 354 of IPC.
My lord, the question
of all these, please.
My lord, the question of sanction, the question unless the cognizance is.
So now none of them is a government servant. That plea is no longer available.
But my lord, when
five of them have retired now.
When the issue pertains to a point of time when they were public servants.
No. But right also, now that plea is not will not apply.
My lord, also during the taking of cognizance, they were public servants.
That's all right. My lord, right now, if it were to go back, that bar will not be there.
My lord, I have provided.
The purpose has been served. The stay is continued for how long now? 10 years. The stay is continued for 10 years, sir.
But my lord, during cognizance, there is a illegality that section 197 should have been followed.
Correct. So for that, there is a stay. The stay is continued for 10 years. Meanwhile, all of you have retired. So that bar will no longer come in the way. All right.
My lord, the one of the petitioner has not retired.
You say
The petitioner number 3 has not retired, my lord. Because he must have been 37.
what is petition number 3?
He was IIC at that point of time.
Where do you say that?
That is in the cost title, my lord.
In 10 years' time, no sanction has been granted.
No, my lord.
How is that?
My lord, only petition for sanction has been requested for the sanction cannot be granted, my lord.
Who's appearing for the state?
I don't have a copy of the petition for some reason. The file is not there.
This is all pending for 10 years, sir.
Apologies.
No attempt to make even to proceed with the investigation, nothing. Where do you say where is petition number 3? Where's the description of petition number 3?
Petition number 3 in the cause and title, my lord. I mentioned at present.
Where is the order taking cognizance?
That is at page number 28. Order dated 2/5/12. And this is a case clearly the present petitioners are discharging their duty. So the
outraging the modesty of the woman is not discharging your duty, please. Don't push it too much.
That is an exaggerated allegation, my lord.
Everything is exaggerated. Only what you say is right. What everybody else says is true, untrue. Can't be, right? Somebody has to inquire into that. Counsel for the state, a copy of the petition be served and counsel of the state will inform the court on the next date. What is the present status of each of the petitioners? And whether sanction for prosecution, their prosecution has been accorded or not, and the reasons therefore. Counsel for the complainant will also obtain instructions on the present status. This on 5th August. Please give him a copy of the petition.
Hello.
Specialist item 15. Item number 15.
None appears to the petitioner. Dismissal, not prosecution. The interim order is vacated. Copy of the order be sent to the concerned court.
Specialist item number 16.
15 both matters. But 16 same order.
Item 16 may be allowed to submit on weekly.
Yes.
Item 16, your lordship.
Yes.
There are 2 points I want to make, your lordship, in this. First is the injury report, your lordship. My lordship has the injury report of Surendra Sahu, your lordship. All injuries are simple in nature. There's 3 abrasion marks only. That's on foot, hand and elbow, your lordship. Two are on foot and one is on elbow, your lordship. That is one point I want to make, your lordship.
No. What is the offense under?
Offense is under 307, 294 and 506 IPC.
You can take all these please, sir, at the appropriate stage. This is not a case for quashing.
Lordship, 307 in this particular case could not have been taken. Cognizance for 307 could not have been taken, your lordship. The injuries are simple in nature. They are just abrasions on his foot and leg, your lordship.
It's all
I'm
right.
facing two judgments of the Supreme Court also in this regard.
This
your
is
lordship.
not the stage for examining that, sir. Sorry.
So we have the injury report, your lordship.
This is not the case for quashing, please. We're only at the prima facie stage. All this can be examined by the trial court.
This is one illegality.
Whether offense in the 307 is attracted or some lesser offense is attracted, the trial court will examine that.
This is the illegality in the cognizance order.
This court anyway cannot convict you for 323 even in their admission. Correct?
Right, my lord.
So where's the question? It has to go to the trial court. Once there is an injury, the trial court will examine the gravity of the injury. You say leaving it open to the petitioner to urge all the pleas raised in the present petition at the appropriate stage in the trial court. The petition is disposed of. The interim order is vacated.
Okay.
Specialist item 17.
None appears dismissed, non-prosecution. The interim order is vacated.
Specialist item 18.
None appears dismissed, non-prosecution. The interim order is vacated.
Specialist item 19.
Yes, my lord. It may please your lordship. The petitioner seeks to quashing of the proceeding in GR case number. GR case number 3549 of 1994 in the court of the JMFC Bhubaneswar under section 447 IPC. The case is dragging on since about 28 years. The occurrence took place on 26/10/1994, and the petitioner regularly appeared before the court, and despite repeated summons and steps, none of the witnesses turned up. The informant is reportedly dead, and the IO has gone insane. The whereabouts of the rest of the witnesses, as appears from the order sheets annexed, in this case, by Annex 1, page number 6 to 11, none of the witnesses, rest of the witnesses are turning up.
So what's your problem then? Then you go back, the whole thing will collapse, the trial will collapse.
Now the question is that
nothing is going to happen to you, sir. Obviously, from what you're saying, nothing is going to happen. You'll get discharged in no time.
This is a case.
You leave it open to the petitioner to urge all the pleas raised in the present.
Just one point. This is someone's procedure case, and the particulars of the offences or substances of the offences were read over and explained on 8/11/2010. Okay, it is. I want to draw your lordship's attention to a decision reported in 2010, 46 OCR, page number 167. That is Devasis Nanda versus State of Orissa, and this honorable court was pleased to drop a proceeding under section 147, 148, 336, 337, 436, 149 IPC, read with section 7 of the Criminal Law Amendment Act, because the proceeding continues for 19 years. And actually, this case,
you yourself got a stay, then how can you complain it's continuing for 19 years?
Because thereafter not me.
You yourself get a stay and then you say
yes, my lord,
for 19 years.
Yes, my lord, the stay continued only after the order passed by this honorable court. The stay order, that is stay order. The case was in the year 2012, and decisions were filed soon after that. And unfortunately, despite our sincere endeavor, the matter could not be listed. It's a summon procedure court, petty offences, maximum punishment is 3 years.
So nothing to 500, sir. Therefore, all your witnesses have died, the complainant has died. What is going to happen in the case? Nothing.
So it is a fit case for quashing of the petitioner is a practicing advocate here.
Yes.
The occurrence took place about 28 years back.
Right.
28 years back, my lord. And there is actually in view of the directives, the dictums of the Honorable Appeals Court in the case of common cause case, that is AR 1996 Supreme Court 1619, this case should have been dropped.
This is a case where you try to enter the secretariat with a toy gun.
That is a secretariat. The rest of the
you got a pass, so let us not get into that at all.
No, my lord, at that time, 447, he was prevented by the constable on duty, and there is no
quite a serious matter.
No question of
quite a serious matter. Yes.
No, my lord, it is not that serious matter. The matter is he regularly
could examine all that. You say leaving it open to the petitioner to urge all the police raised.
Okay, one thing I want to submit, then I may be permitted to file a petition under section 258 CRPC.
You have to be permitted, sir.
Yes.
High Court has to permit you. Is that the law? Yes. Leaving it open to the petitioner to urge all the pleas raised in the present petition at the appropriate stage in the criminal court. The petition is disposed of, the interim order is vacated. A copy of the order be communicated to the concerned trial court forthwith.
With liberty to file a petition.
Specialist item number 20.
None appears, dismissal not possible. Both matters. The interim order. Copy of the order be communicated.
Specialist item 21.
21, no instruction, your lordship.
Counsel petitioner states he has no instruction. Dismissed. Interim order is vacated.
Specialist item number 22.
May I please, my lord? In this case, the petitioner has already married to the victim girl and they are blessed with a male child, my lord.
Okay. Statement of the victim girl under section 164 CRPC.
As a copy may be given.
This is the manual photocopy of
Confirms
the
that.
And I have annexed her to at page 13.
Confirms that she has married the petitioner of her own free will and is residing with him. They are also blessed with a child.
Male child.
Male child. In that way, the matter, the GR case number 1527 of 2011, pending the court of SDJM Badrak, and all constitutional proceedings are hereby quashed. The petition is disposed of.
Specialist item 23.
None appears, dismissal non possible. Interim order is vacated.
Specialist
Copy
item
of the order be
24.
communicated.
Item number 24.
None appears, dismissal non possible. Same order.
Item number 25.
None appears, dismissal non possible. Interim order is vacated.
Specialist item 26.
Madam, please, your lordship, madam.
In this application, 2, my lord. I have not received. I am the respondent to opposite 2, my lord.
Yes, please.
Madam, in this application, the petitioner challenges the order of taking cognizance, my lord, offense under section 406 of IPC, my lord. And fact of the case is that the informant lodged the FIR on 10/3/2012, alleging therein that by virtue of an agreement, the petitioner had taken 2 trucks on a hire basis and to pay 7,000 per month, but he did not pay the amount and absconded along with the truck. Subsequently, in 2011, 1 truck was recovered, my lord. Thereafter, he lost this FIR, my lord. My respectful submission is, my lord, by virtue of an agreement, the civil remedy is there, my lord. No criminal case is made out, my lord. And by then, my lord, petitioner, my lord, I have annexed the annexure 4, my lord.
Yes.
My lord, petitioner is working. Joined, my lord, since 4/12/2010, my lord. And he has stated that, my lord, FIR has been lodged on 10/3/2012, my lord.
Leaving it open to the petitioner to urge all the pleas raised in the present petition at the appropriate stage in the criminal court. The petition is disposed of, the interim order is vacated. Copy of the order be communicated to the concerned court further.
Item 27.
May I please? But in this case, liberty may be granted to hesitate all the prior learned particulars.
All right. Need to withdraw with liberty to urge all the pleas raised here at the appropriate stage in the trial court. The interim order is vacated. Disposed of is withdrawn with liberty is paid for.
Item 28.
28 also same lord.
Same order in 28. All right.
Specialist item 29.
May I please, Your Honor. Sir, I am for the petitioner. Praying to quash the order of cognizance and the entire proceedings in GR case number 3433 of 2009 corresponding to Baragoda PS case number 171 of 2009. May I please, Your Honor. Paragraph 4, 5 and 8 in my petition says that on the basis of a lease deed, fabricated lease deed, the OP number 2 has filed this affair, and this court, the Honorable Court, this has passed an order in WPC number 28534 of 2013, dated 22/1/20, directing to the commissioner to produce the document.
This is a 2014 case, sir.
Sir, my lord,
And the GR case is 2009.
my lord,
You can urge all these pleas, sir, at the appropriate stage.
my lord, see, paragraph 4, 5 and 8
Yes.
in my petition would speak.
The charge sheet has already been filed.
Yes, my lord, charge sheet has been filed on the basis of the opposite party number 2, my lord.
Whatever, sir, let the court examine it, reserving the right to the petitioner to
My lord-
urge all the pleas raised in the present petition at the appropriate stage in the trial court. The petition is disposed of, the interim order is vacated. Yes.
Specialist item 30.
May I please, Your Lordship? Here, my lord, challenging the proceeding, my lord, on the ground that the affair is not maintainable, my lord. Because there is a specific provision, my lord, under section 16 of the Orissa Kenduli Act, my lord. The competent authority has to file complaint before the competent court, my lord. Here, my lord, Your Lordship, the affair has been filed by a police officer. That has been under challenge, my lord.
What is the statute you said?
Can Orissa Kenduli Control Trade Act, my lord.
There's only one, sir.
My lord.
Otherwise,
Arising out of this,
379 411 34 IPC.
pardon, my lord, arising out of this, my lord, this offense has been added, my lord. The principal of
The offense is not only under the Kendo leave.
my lord,
It's also under 379 411.
my lord. The principal offense is, my lord,
Yes.
section 14 of the Odisha Kenduli Act. Arising out of that, my lord, 379 has been technically added. Because section 14 itself is the theft of Kenduli, my lord.
Sir, both offenses are attracted, then you can't say that it's only under Kendo Leaves Act.
Apart from that, my lord, there is specific bar, my lord.
Yes.
Only a competent authority can file the complaint, my lord. That is DFO and any authorized officer by the state government or central government. Here, police officer is not the authority.
What's your instruction, please?
They can, because the offenses, although under the Principal Act is the Kendo Leaves Act, the section 379 is also attracted.
How is it attracted?
It's a theft. It's a theft.
Where do you know it? How do you know it's a theft? Theft of what? Who gave a complaint about theft? Did anyone give a complaint about theft?
Well, it's the patrolling party.
That is intercepting a truck. You intercept so many trucks, you find that there are no supporting documents, you seize the truck. How does it become theft?
This can be urged before the trial court.
Why, if it's non-cognizable only, if it's cognizable only in a complaint of the inspector?
Let me examine Millards and come back.
Counsel for the state needs time to examine the matter. Copy of the petition be served on interim order to continue list on 5th August.
Special list item 31. Item number 31.
None appears dismissed, not possible. Interim order is vacated.
Special list item 32.
May petitioner is challenging the cognizance order passed by the JMFC. I bring to your lordship attention to my petition, page 6, paragraph 13, that all the petitioners are government officials. And without sanction, the cognizance was taken.
Sir, all of them now retired, I think.
No, nobody has retired. All are in service.
Mr. Katke, what is your
I have to take instruction.
because it's a copy of the petition be served on Mr. Katke today itself to enable him to take instructions. Interim order to continue list on 12th August.
Sanction can be obtained at any time.
Sorry?
Sanction can be obtained even during the course of trial.
Sanction been obtained.
Can be obtained at any time. Can be obtained at any.
Can is one thing, sir. It's already 10 years now. Better find out what's happening. Yes.
Special list item 33.
None appears dismissed and non-prosecution. Interim order is vacated.
Special list item 34.
None appears dismissed and non-prosecution. Interim order is vacated.
Special list item 35.
None appears dismissed and non-prosecution. Interim order is vacated.
Special list item 36.
Same order.
Item 37.
It may be disposed with liberty to raise the.
Seeks leave to withdraw this liberty to urge all the pleas before the trial court. This post office is withdrawn with liberty is paid for. The interim order is vacated.
Special list item 38.
May I please, your lordship, my lord, on behalf of Mr. V.K. Ragada, I am appearing that, my lord. In this case, questioning of the FIR, my lord, offence under section 341, 294, 354, 509, 506, and 34 IPC, my lord. My lord, my petition copy, page number 3, my lord, paragraph 4, my lord. The petitioner and the informant was meeting between both the parties and amicably settled between these parties, my lord. Kindly.
There's nothing to show that, madam.
Petition number, my lord, my petition copy, page number 3, paragraph 4, my lord.
That's all enough. You have to submit an affidavit of the person.
Affidavit.
This is not enough. Permitting the petitioner to urge all the pleas raised in the present petition at the appropriate stage. The petition is disposed of, the interim order is vacated. All right.
Special list item 39.
None appears dismissed and non-prosecution. Interim order is vacated.
Special list item 40.
40 may be mercy. So in this case, the present petition challenge the classmate set aside of criminal proceeding against the present petition violation. The accused opposite of waiver and opposite of 3 men of law and affection is voluntarily respectively and materialized by marriage mercy. Under section violation, which is if a charge sheet has been filed against the present petition marriage. Section under section violation 363, 366 and 376, 109 and 34 IPC. The offence against the present petition is 109. In case of abandonment,
To file an affidavit of the victim. Where is the affidavit of the victim? That's not there.
Yes, ma'am, the charge sheet has been filed against me, my receipt, in the page number 14, my receipt. But in my place is only abatement 109 offense is 109 of IPC is liability measure. I was only in the vehicle measure in which the opposite party number 3 and 4 who was fled away from her house, my lordship.
Can urge all these pleas, sir, at the appropriate stage. You say permitting the petitioner to urge the pleas raised in the present petition, the appropriate stage before the trial court. The petition is disposed of, the interim order is vacated.
Specialist item 41.
Case for praying for passing the order of cognizance taken by the Lord JMFC.
What are the offences, sir?
The offences is under section 294, 506 and 380. Is arising out of a complaint case. The complaint was submitted before the Lord Magistrate after 2 months after the alleged incident. No explanation is there. However, the Lord Magistrate has sent the complaint for sent to the concerned police, who investigated thoroughly and submitted a report that is a false affair. After that, the magistrate has taken witnesses as per its jurisdiction and taken cognizance.
So, okay, so you can urge all the pleas raised in the present.
May I
at the
pray, my lord?
appropriate stage.
May I pray, my lord? My lord, the date of complaint and the cognizance taken by the Lord Magistrate is 4 years. The maximum punishment, in the offense under section 380, the Lord Magistrate could have been taken the cognizance within 3 years, my lord. It is after 4 years, my.
You can urge all this, sir. You can seek discharge on that ground. Permitting the petitioner to urge all the pleas raised in the present petition at the appropriate stage before the trial court. The
I may
petition
be
is dismissed.
protected, my lord.
No need, sir. Already nothing is happening. So many years have passed. Interim orders vacated.
Item 42.
May I please, Your Honor? The alleged offence 341, 294, 323, 376, 511, 506 IPC, my lord.
You urge all this at the appropriate stage, sir.
My lord, opposite party to have entered the appearance. There is a compromise between the parties.
376.
511, my lord, not 376. 511 attempt is there. And subsequently development is that, my lord, the victim married and also entered the appearance after issuance notice by this honorable court, my lord.
You are
I'm for the victim, my lord. OP number 1.
You
I filed my affidavit. I filed my affidavit that the matter has been settled between the parties.
All right. The victim has filed an affidavit stating that the issues have been settled with the petitioner. Counsel appearing on behalf of opposite party number 2 also confirms this in court. That view of the matter, GR case number 117 of 2013, pending in the court of the JMFC Salipur and the order dated 6th January 2014, passed by the JMC taking cognizance, and all other proceedings pursuant thereto are hereby quashed.
Great.
Victim has married in the meantime as stated by the land.
Married.
And that they've married. They settled the disputes and they've also married for it.
Specialist item 43.
May I please, Your Lord? Here, my lord, the petitioners are the 2 directors of the mining company, my lord. I challenge the order under Annex 2, my lord, which has been taken by the Lord STGM Bonai under section 15 of the Environment Protection Act, my lord, which the London court below should not have taken, because the company, my lord, has taken all precaution steps, my lord, for the running of the company, my lord. And on the allegation of the opposite party number 2, he has taken the cognizance, my lord, saying that there are some allegations of violation of the norms, which has in the meantime has complied, my lord. That is why notice has been issued and the very order has been stayed by this honorable court, my lord, in 2000.
Staying is almost routine. Whenever notice is issued in these matters, stay is granted immediately.
No, because looking at the
environment offences are serious, sir. You say leaving it open to the petitioners to urge all the pleas raised in the present petition the appropriate stage before the trial court. The petition is disposed of. The interim order is vacated. A copy of the order be communicated to the concerned court forthwith. Yes.
Specialist item 44.
May I please, Lordship, liberty may be granted to us the all prayer.
All right. Counsel the petitioner seeks leave to withdraw the present petition with liberty to urge all the pleas raised here at the appropriate stage of the trial court. The interim order is vacated. This post of is withdrawn with liberty is grateful.
Specialist item
Copy of
45.
the order be communicated to the concerned court forthwith.
May I please, Your Lordship? My lord, here the petitioner has prayed for quashing of the criminal proceeding on the basis of the compromise entered between the husband and wife. My allegation under section 498A, annexure 2 is the compromise that has been filed before the IIC Mahila Police Station, Bhubaneswar, my lord.
There's no
Notice was
statement of the, there has to be some statement, affidavit filed, sir.
Yes, my lord, I'll take, keep it, Your Lordship may keep it to next week, so I'll.
Mr. Raut states that.
Notice has not been served on open number 2. But she is staying with me.
All right, that he will file the affidavit of opposite party number 2 before the next date. List on 5th August. 5th August.
My
All right.
interim order to continue.
Interim order to continue.
Obligement.
Specialist item 46.
None appears, dismissal, non-prosecution. Interim order is vacated.
Specialist item 47.
None appears, dismissal, non-prosecution. Interim order is vacated.
Specialist item 48.
Same order, same order. None appears, dismissal, non-prosecution.
Specialist item 49.
None appears, dismissal, non-prosecution. Interim order is vacated.
Item 50.
None appears, dismissal, non-prosecution. Interim order is vacated.
51.
None appears, dismissal, non-prosecution. Interim order is vacated.
Specialist item 52.
Dismiss for non-prosecution. Interim order is vacated.
Sir, 52 is the CRLMC
52.
41 114.
You have to speak in the mic, please.
Sir, CRLMC 4211/14.
Yes, yes.
Yes, sir. Sir, my humble prayer is the quashing the complaint petition in view of the compromise, sir. Sir, petition has to pay total amount and compromise petition is on record, sir.
1 minute.
And 3 times has sent the requisites against the opposite party. Till now, he is not appear, sir.
Where is the compromise petition?
No, there is a report from the London CJM Cuttack, Your Lordship can permit. At flag B, there is a report.
That report is on something else about delay in passing some judgment.
Just I have brought it to Lordship's kind notice.
Sorry?
Just I have brought it to Lordship's kind notice.
I know, but I don't know what that has to do with the main matter. Where is that to show if there's any compromise? And they have not been able to be served. No such person at the address.
Sir, notice has sent 3 times.
Can't be helped unless they served. How do we get to know whether there's a compromise or not?
So, sir, time may be given, sir.
No. You see to see that despite several attempts, opposite party number 1 has not been served. The circumstances leaving it open to the petitioner to urge all the pleas raised in the present petition to the appropriate station in the trial court.
Sir, interim order maybe, sir, continue, sir.
No. The interim order is vacated. You'll have to appear before the trial court now. The petitioner will appear before the trial court. On 11 July. Right.
Specialist item 53.
Obliged.
Made, please, Your Lordship. Your Lordship, the allegation of the complainant is under section 419, 420, 468, 471 IPC against the present petitioners, my lord. My lord, the peculiarity in this particular case is that the name of the father as well as the grandfather of the complainant as well as the present petitioners are the same. They are identical, my lord. Hence, the allegation is that the present petitioners have sold the land of the complainant's father and they have forged the documents.
Yes.
And they have stated that the complainant's
on the
father is
very face of it requires a trial to be conducted.
my lord. There
Without
is
a trial, all this will not emerge, sir.
yes, my lord. My lord is absolutely correct, but there is a plaint that is pending that I have annexed.
Yes.
And in that plaint, the main issue that has to be determined is whether the parents of the complainant and the petitioner are the same or not. And without that issue being determined,
so that's what is pending for the last 9 years.
Yes, my lord.
So
In that case, we have filed the written statement which is pending for appreciation, my lord. My lord, may kindly appreciate that continuance of this proceeding would not yield any fruit because of the fact that we have taken a ground.
This criminal case hasn't moved an inch.
My lord, in the criminal case, in the criminal proceeding, it has also not proceeded, and we have instructions that
because you've come here and got a stay, that's why.
No, my lord, we have not obtained a stay. We have an interim order of no coercive actions being taken against the petitioner. The proceeding and
Model
not
like this means everything comes to a standstill.
Lordship, this is completely a civil dispute, my lord. I have a recent judgment. If your lordship may kindly appreciate.
What has happened in the criminal case? You tell us.
My lord.
You tell me what has happened in the criminal case.
My lord, in the criminal case, the present petitioners, they have sold off a land.
No. What is the stage of the criminal case? According to you, only no coercive steps were asked to be taken against you.
Yes, my lord.
Did the criminal case proceed?
No, my lord.
Then
the criminal case has not proceeded.
That's the whole thing. That's how they understand the stay orders. They think there's a complete stay. You say leaving it open to the petitioners to urge all the pleas. Petitioners to urge all the pleas raised in the present petition at the appropriate stage in the trial court. The petition is disposed of. The interim order is vacated. A copy of the order be communicated to the concerned trial court forthwith.
May I pray, Your Lordship? I'm for the opposite party number 2.
Anyway, we've disposed it off.
Yes, Your Lordship. I'm just submitting a note of submission along with a judgment.
Okay. All right.
Specialist item 54.
My presence may be recorded.
Yes.
Grateful, my lord.
Obliged.
54.
None appears dismissed, not possible. The interim order is vacated.
Specialist item 55.
The memo is taken on record. The petition is dismissed as withdrawn. The interim order is vacated.
Specialist item 56.
56, may I please, Lordship, by virtue of the compromise petition, the petitioner wants to question the order of cognizance, my lord. The annex 3 is the compromise, my lord, filed by the informant, my lord. Apart from that, the counter affidavit also filed by the informant in paragraph 8 and 9.
All right. The counter affidavit filed by opposite party number 2 confirms that the disputes have been settled between the parties. And a statement to that effect has also been made on affidavit before the executive magistrate Cuttack. Accordingly, GR case number 67 of 2013 pending the court of the JMC Salipur, corresponding to Jagatpur PS case number 201 of 2013 and all proceedings consequent thereupon, including the order taking cognizance are hereby quashed. Including the order dated 25th February 2014, taking cognizance are hereby quashed.
Item 57.
I have challenged the proceeding, the domestic violence act. My sole prayer, my lord, that the no opportunity is given for counseling the matter, because the petitioner is the husband and he wants to keep his wife, and that's why under annexure 4, because matter was referred to the counselor, but it could not be due to absence of the parties, it could not be done, and so that's why, since I have already filed CP for restitution of conjugal rights in other court, so that's why I approached this honorable court, because the simple prayer is that.
Say, as short of compromise, nothing can happen in these matters, sir. You know that. Say, leaving it open to the petitioner.
If counseling will be held, my lord,
Sorry?
If counseling will be held, so.
Not at this stage, sir. 2014 matter. By now, you should have exhausted all those possibilities. You are appearing for the
opposite party wife, my lord.
Already
there is direction for counseling, but it was failed due to non-appearance of the parties. It is pending since 2013, my application order.
You can always go before the trial court and again ask for counseling there. Leaving it open to the petitioner to urge all the pleas raised in the present petition the appropriate stage in the trial court. The petition is disposed of, the interim order is vacated. Copy of the order be communicated to the trial court.
May I pray, my lord, since it's a case of 2013, you also may kindly direct for specific direction to dispose of the case.
So if you're compromising, you go there and you ask for compromise.
There is no chance of compromise, my lord. I am for the
All
right.
right. That's all.
Item 58.
File this case for quashing the affair.
I am appearing for the OP number 3, my lord, father of the victim, my lord. Victim has already married and blessed with a male child. I do not want to proceed with this case.
I see. Counsel appearing for opposite party number
3, my lord.
3 states that does not wish to proceed with the case. The statement of opposite party number 3 on affidavit is also on record. The same effect. In that view of the matter, GR case number 688 of 2013, arising out of Astaram PS case number 67 of 2013, pending in the court of the JMFC Nimapada, and all proceedings consequent thereupon are hereby quashed. Correct.
Specialist item 59.
May I please, item 59. I'm challenging the proceeding. In this case, in the meantime, the matter has already been settled.
My lord, amicable settle between the parties.
All right.
I am from the opposite party number 2, my lord.
Opposite party number 2 confirms that the matters have been amicably settled between the parties. In that view, the matter, GR case number 106 of 2012, 108 of 2012, arising out of Jagat Singhpur, PS case number 20 of 2012, pending the court of the SDJM Jagat Singhpur, and all proceedings consequent thereupon, including the order dated 9 July 2012 taking cognizance, are hereby quashed. Copy of the order be communicated to the concerned trial court.
My lord, on that way, I may be file an affidavit that amicable settle there. Thereafter, that may be disposed of.
You're waiting for the order to be dictated and then you're saying this.
Sorry, my lord. I'm sorry.
Order.
I'm sorry.
Item 60.
Item 60, let's say no instruction, may liberty to, if cause of action survive, may again approach your before, let's say. Item 60.
If you have no instructions, it's no instructions, sir. Counsel petitioner states he has no instructions. The petition is accordingly dismissed. The interim order is vacated. Copy of the order be sent to the concerned trial court.
Okay. I may be pardoned, my lord. Item number 37, your lordship disposed with liberty to raise all the pleas at the appropriate. However, the petitioners are not on bail. Therefore, my lordship,
petitioners are not on
bail.
Not on bail. So,
my lord, may kindly consider their bail.
No, not here. Not.
Pardon, my lord. Item number 34, my lord.
Yes.
It was dismissed due to non-appearance, my lord.
All right.
I was.
Tell us what it is. Yes,
My
proceed.
lord, in this case, my lord, I have filed for quashing of the proceeding on the ground of compromise, my lord.
34.
34, my lord. here the informant, my lord, he has already filed an affidavit before the court below, but those affidavits are not accepted by the court.
That's right. You'll have to get the affidavit properly. You produce the person, that's the best. And even here, she has not filed any affidavit.
It was affidavit was made before the serious or before the trial court. But
Here, you have not filed any affidavit of opposite party number 2.
here, my lord, notice has been issued to the.
But she's not appeared, sir. See, without an affidavit of the victim, there's no question.
So my predicament, non-appear has been reflected in the order sheet. That's
All right, you say permitting the petitioner to urge all the pleas raised in the present petition at the appropriate stage before the trial court. The petition is disposed of, the interim order is vacated. Copy of the order be communicated to the concerned trial court.
obligement.
Over. Yeah.
Supplementary list for orders, item number 1.
Please, my lord.
Yes.
Lord, in this appeal, there are 14 appellants, my lords.
Yes.
Out of these 14 appellants, my lords, I had earlier moved for bail in respect of certain appellants. They are, your lordship may see the order dated 29/11/2019.
Yes.
My lords, their bail was moved for appellants 3, 4, 5, 9, 11, and 12.
Right.
The division bench consisting of my lord Justice S.K. Misra as he then was and Justice Rautray rejected prayer for bail of appellant number 12 and granted bail to the other appellants, my lords. And this was because they had not been named by the informant in her 164 CRPC statement.
Yes.
Thereafter, my lords, I have filed the present application for bail, my lords, relating to the other appellants, my lords, whose prayer for bail was not considered. That is IA number 1806 of 2019, my lords, at flag D, my lords. Appellants 1, 2, 6, 7, 8, 10, 13, and 14.
Yes.
That has not been taken up, my lords, and I filed the second application, wherein I also added appellant number 12. That is how the matter has come before this bench. Your
Right.
lords, see IA 972 of 21 at flag F, my lords.
Yes.
Now, my lords, all these appellants, they were facing trial before the London Additional Sessions Judge, Raigada, my lords, in city case number 33 of 2018, my lords.
Yes.
And they are in custody, my lords, since 2017, my lords. They are all Adivasi, my lords.
What about previous antecedents?
No antecedents, my lords. They have no previous antecedents. They were
That I have not obtained.
suspecting. They were.
I have obtained the antecedents. That is there. But here this is a case of corpus delicti. Of course, they have taken suspecting that that person is playing sorcery. Plus that person was assaulted and it stand on the way, and thereafter he was assaulted and was taken to the graveyard in the night and was burned there. And subsequently, only some burnt ashes, some bones, those are recovered. So that will be put to postmortem. This is a clear case of corpus delicti. So PW2, your husband kindly peruse that is paragraph 1. I am permitted to read it. So my husband is the deceased of this case. The incident took place prior 3 months back. One day at about 9 p.m., I along with my husband were returning to our hut from our culpable land. On our way, the accused Gumpa came to our front and wrongfully distanced us. At that time, the accused Dandasa assaulted my husband by means of a lathi on his head. Immediately, the other accused persons who were also present there started attacking my husband by means of lathis. Due to the assault, my husband fell down on the ground, having sustained bleeding injury on his head. Immediately, I rushed to our house and intimated about the incident to my brother-in-law. When I, along with my brother-in-law and villagers, again proceeded to the spot, we found my husband was not there. Paragraph 2, we searched for my husband but could not trace him out. On the next day, we went to the graveyard of our village and found the dead body of my husband there in a half-burnt condition. And he has identified.
I am much obliged to my learned friend.
I am not saying. I am not finished.
But should I not have the opportunity of placing my case first before he begins?
No, I have not begun. I'm sorry.
or if the situation has changed and it is the state which is to place my bail application first, let him complete. Then
I am not representing my learned senior has completed.
All right.
I am not that Upanishad.
Yes, Mr. Panda.
Lords, with due respect, my lords, all these petitioners, along with the petitioners whom your lordship has been pleased to release on bail, were put on trial for a case of murder, my lords.
Yes.
Now, the entire case, my lords, is based on the statements, my lords, which were recorded during investigation. At the trial, my lords, will see all of the witnesses have turned hostile except PW2. And what has happened is, as regards the recovery of the body also, my lords, the evidence, my lords, is not above board, my lords. If your lordship will look at the evidence of PW2, which my learned friend placed before your lordship, her evidence is this, that on our, I'm placing from the fourth line, my lords, on our way, accused Gumpa came to our front and wrongfully restrained us. At that time, accused Dondasa assaulted my husband by means of lathi on his head. Immediately, the other accused who were also present there started attacking my husband by means of lathis. Due to the assault, my husband fell down on the ground, having sustained bleeding injury on his head. I rushed to our house, immediately intimated about the incident to my brother-in-law. When I, along with my brother-in-law and villagers, again proceeded to the spot, we found my husband was not there. We searched for my husband but could not trace him out. On the next day, we went to the graveyard of our village, found the dead body of my husband there in a half-burnt condition. At the time of incident, I was having a torch with me. In that torchlight, I identified all these accused persons. During investigation, I was produced before a magistrate and my statement was recorded before her. Now, your lordship may look at the cross-examination. Paragraph 4, I was examined by the police within 2 days of the incident. It's not a fact that I have not stated before police that accused Dondasa assaulted her husband by means of a lathi on his head. It is also not a fact that I have not stated before police that accused Gumpa wrongfully restrained her. It's also not a fact that I have not stated before police that due to the assault, my husband fell down on the ground having bleeding injury on his head. I cannot say specifically which accused assaulted which person of my husband. I only noticed all of them were assaulting my husband all over his body. It's not a fact that due to darkness, I have not seen the face of the accused persons. Then para 6, it's also not a fact that I have not stated before the police that the accused persons, while assaulting my husband, were asserting that they would kill him as he was practicing sorcery. It's not a fact that at the instance of police, I stated before magistrate about complicity of the present accused, that I have not stated before magistrate that on the day of occurrence, we searched for my husband, but could not trace him out. It is not a fact that I have not identified the body of my husband at the graveyard, not a fact that the body was not in a condition to be identified. It is a fact that other dead persons were also cremated in their graveyard. Now, as regards the witness number 3, my lords, he is a hearsay witness, my lords. That is apparent from the 4th line of his evidence. I was present at my village. Wife of the deceased appeared before us and intimated us while crying that the present accused persons have assaulted and killed her husband, while both were proceeding to the hut situated at their cultivable land. PW4 also, your lordship may see. This is regarding the recovery of the body. He says in the 3rd line, we went to the graveyard of the village. There we find a half-burnt body having size 1 to 1.5 feet lying there. On the spot, I collected 5 numbers of bones, the skull, burnt ashes, and some earth.
Wouldn't have identified the body.
My
Yeah.
learned friend says that it's a case of corpus delicti, my lords. There is no chemical examination
Right.
at effect.
Dandasi and Gumpa. Already spent 5 years or 6 years, sir?
Already since 2017, my lord, 6 years.
5 years.
5 years, I'm sorry. And your lordship may see the evidence of PW11, the DFSL, my lords. He says, we went to the graveyard of the village, found a skull, 5 numbers of bones, and a half-burnt wood from the spot. He doesn't say about any chemical examination.
What about DNA to confirm that it was the
No,
disease?
my lord, no DNA, nothing, my lords.
How do they do this? It's so basic.
And before the IO has been confronted with the contradictions, my lords. Paragraph 20, your lordship may see of the IO.
Yes.
He is PW 19, my lords. Para 20, he says, it is a fact that PW2 has not stated before me that the accused Gumpa wrongfully restrained her husband, though she was present there. It is a fact that PW2 has not stated before me that while accused were assaulting her husband, they were asserting that they would kill him as he was practicing sorcery. And they are all Adivasi people.
Yes, she's a rustic lady, plus the very on the first part of the deposition also we find the witness doesn't know the Odia language, is only able to communicate in the Kuli dialect.
Every witness here has been translated from the Kui language. The accused persons also, my lord, they don't know Odia. They also speak Kui.
Yes, Mr. Panda, 1 minute. Mr. Katkia, have you seen the evidence of PW2?
No, I don't have that.
No, PW2's evidence you don't
Yes,
have.
yes, that is there.
So that is the only vital key witness.
Yes.
So as per her evidence, she has seen only Dandasi giving one lateral blow on the head of the.
And even the IO now says that she did not say that to him.
That is there.
You see, this is an application by appellant numbers 1, 2, 6, 7, 8, 10, 12, 13, and 14. Seeking enlargement on bail during the pendency of the present appeal, which is directed against the judgment dated 24th January 2019, passed by the Sessions Judge Raigada.
Additional
Sessions Judge Raigada in CT number 33 of 2018, convicting the appellants for the offences under sections
147, 148, 302, 201, 506, read with 149.
Yeah.
506, they have been acquitted. 148, 147, 148, 302, 201, read with 149.
149, right. The petitioners have been sentenced to imprisonment for life for the offense punishment at 302/149 IPC. And the sentences for the other offenses have been asked to run concurrently. Paragraph. This is a case of corpus delicti with the deceased being suspected. According to the prosecution, the disease was suspected by the accused of practicing sorcery and was therefore attacked by them at around 9 p.m. on the night of 18th November 2017. Paragraph. As it transpired in the trial, this was further, this was a case of corpus delicti, as only 1 to 1.5 feet of the dead body was discovered on the succeeding day in the cemetery in a burnt condition. Paragraph. As it transpired at the trial, the prosecution witnesses, independent prosecution witnesses, turned hostile, except PW2, who happened to be the wife of the victim. Full stop. The perusal of her deposition shows that she was returning to the village with her husband at around 9 p.m. on 18th November 2017, when accused Gampa is stated to have come in front of them and wrongfully restrained them. She further states that at that time, accused Dandasa assaulted the victim by means of a lathi on his head. And that, open quotation, immediately the other accused persons who were also present there started attacking my husband by means of lathi. Unquote. She claims to have rushed to her house to inform her brother-in-law of the incident. And when they returned, they found the husband missing. Stop. It's only on the next day that they found a half-burnt body in the graveyard. Full stop. She claims to have identified all the accused by means of a torchlight that she was carrying. Paragraph. What is interesting is that in the examination of the IO bracket PW20, it emerges that during investigation, she did not inform him of accused Dandasa assaulting the husband by means of lathi. The second fact that emerges is that she did not actually see assault by the remaining accused of the husband, leading to his death, as by the time she returned to the spot, the husband and the other accused were all missing. Full stop. She therefore is not aware of which accused assaulted the husband in what manner. Paragraph. The further factor to be noted is that there was no scientific evidence to back up the case of the prosecution that the skull and bones found on the following day at the graveyard actually belonged to the husband of PW2, that is the victim. Stop. Paragraph. It may be noted here that the remaining accused have already been enlarged by this court on bail by its order dated 29th November 2019. Paragraph. This court has heard the submissions of Mr. Devashish Pandal and counsel for the applicants and Mr. Katkel and AGA for the state. It is not in dispute that barring PW2, there is no other prosecution witness supporting the case of the prosecution. Full stop. Her evidence prima facie makes out an argument case for the appellants. Mr. Katkias does not dispute the fact that the appellants have been in custody since
November
2017. November 2017, that is almost 5 years now. It is unlikely that the present appeal in its turn will be taken up for hearing in the immediate future. Keeping in view all the above factors, the court directs that during the pendency of the appeal, the present applicants, that is appellants number 3, 4, 5, sorry, 1, 2, 1, 2, 6, 7, 8, 10, 13, and 14
12,
be
13.
enlarged on bail,
10, 12.
subject to the satisfaction of the trial.
Lords,
The
12,
application
your
is
lordship
disposed
left.
of.
Your lordship left out 12. Actually,
Okay,
this order
12.
has to be passed in IN.
No, Mr. Pata, 1, 2, 6, 7, 8, 6, 7, 8, 10, 12, 13, and 14.
12, 13. Yes, yes. All right.
And well, the submission of my Lord Senior that he is in custody for that period, because I am not verified the custody period.
But we have, all right.
The others were granted bail. That's why I moved bail for the others initially.
But the understanding of that poor rustic lady is not the same as the understanding of my Lord Senior.
All right.
Much obliged. देखिले मते तो कटके
Supplementary list for orders, item number 1. May please, Lordship.
Yes, please.
Yeah, the matter was dismissed for non-prosecution on 9th July 21. But at that time, I was suffering from COVID-19. That's why.
What's the main matter about?
Main matter is the implementation order of this honorable court by the Tahsildar Jatni.
Implementation meaning?
One order was passed.
For which you file another writ petition. You should have filed a contempt petition.
No matter what, there was some delay in filing the.
That doesn't mean you file another writ petition.
To avoid the delay in filing the contempt. No, there is not a delay at all. I have filed the petition in delay, but I have all the initiation was started. I gave the copy of this honorable court to the Jatni for muted the land in my favor. Thereafter, they did not take any step. Thereafter, I filed under RTI. That what action you have taken on not the.
What was the order passed with this court? Let's see that. 2016.
Pardon.
The first order passed by this court.
First order was page 13 of the writ petition. I'm just reading out.
No, that was only quashing a
Order was the Honorable High Court quashed the resumption order of the Tahsildar Jatni.
All right.
When the resumption was quashed,
right,
I am entitled to get the land mutated in my favor.
Right.
That's why I supplied the copy of this.
But there's the question of implementation.
Yes, once the resumption is quashed, mutation is not
automatic. Exactly. Where's the question of non-implementation of the order?
Whether the government has preferred SLP or not against that order, that is also not on record.
But where's the question of non-implementation?
When the resumption was quashed, I filed the copy of this order along with the mutation application. That will be decided. That was pending. When there are no steps taken by the Tahsil office Jatni, I approached through RTI. I have filed.
No, where is an order by this court directing him to grant mutation in your favor? There's no such order.
No,
If the mutation is pending for a long period, so against that inaction, he can approach the single bench for disposal of the mutation.
Correct.
What happened when mutants, they have stated in the under RTI, we have as you have not supplied, you have not appeared.
Whatever, sir, whatever.
Yes,
I'm saying the remedy for that
must be some
ask for a
information.
direction to the Jatni Tahsildar to carry out the mutation.
Yes, I have.
That is what you have prayed for here is about non-implementation of some order of this court. That's not even, that's completely
That is
misconceived.
why it is listed in division bench.
Yeah. All right, you say for the reason stated, the application is allowed and the order is recalled and writ petition 38420 of 2020 is restored to file. Then in that writ petition, you say, having heard learned counsel the petitioner, it appears to the court that the prayer that a direction should be issued to the opposite party to implement the order passed by this court on 6th December 2006 in writ petition civil 15094 of 2006 is misconceived. That order merely quashed an order of resumption passed by the Tahsildar, additional Tahsildar Jatni, and did not contain any specific direction to him to carry out the mutation in the record of rights in favor of the present petitioner. Paragraph counsel the petitioner states that his application for mutation has been pending for a long time. In that event, it will be open to the petitioner to institute appropriate proceedings seeking specific directions to the Tahsildar in that regard. Granting the petitioner that liberty, the present petition is disposed of. All right.
Obliged.
All right.
Application that dismissed for default.
What's the main matter about, sir?
Main matter that is PIL is a illegal recording of government land in favor of a private person. Government has filed counter and I have filed the rejoinder. Subsequently, your lordship directed the private opposite party to appear on 22/2/2002, but he did not appear. Then your lordship directed the for telephony information and appear on 4/5/2022. On that date, that case was dismissed for default. The main case is like that. My lord, this is a land where the Pani Nala, that government land, recorded by way of a municip civil suit case. That civil suit case, government has not filed the WS. But by way of that, he mutated the case. And against this municipal order, government prefer an appeal. And appeal dismissed for default without taking any steps. Subsequently, they already counter and rejoinder affidavit filed. But your lordship desired to appear by the private
affected party was opposite party number 7.
Yes, my lord.
And he never filed an affidavit.
No. No, what has happened, my lord? This beneficiary, he obtained a civil court decree against the government. And by that, on the basis of that, he applied for mutation and got the name recorded in respect of the land in question. Thereafter, government also preferred appeal against that expired decree. That was also dismissed. These are the facts. And he is now saying that that mutation order is illegal. It should not, because it is a Pani Nala case, that is why it should not. The only way your lordship can direct him to file appeal, because that order is available before the sub collector, that mutation order. If he is at all aggrieved, he can file the appeal before this. There is no question of pending the case here.
Government land, my lord.
Yes, so you can file an appeal.
That liberty your lordship can give him to file appeal before the sub collector Baleswar.
All right. You say for the reason stated, the application is allowed and writ petition civil 11211 of 2018 is restored to file by recall of the order dated
4/5/2022.
Sorry,
4/5
2022. 4/5/2022. And then in the main PIL, you say the grievance of the present petitioner is about the mutation carried out in favor of opposite party number 7 in respect of land situated in village Sahadev Khunta, unit number 2 in district Baleshwar, bearing ROR 513, plot number 849, on the basis of an ex parte decree obtained against the government. It is contended that the land is actually a Nala Kisam, is it?
Yes, yes. Nala Kisam.
Nala Kisam.
Pani Nala.
Pani Nala.
It is water body.
Pani Nala Kisam. That is a water body and should not have been mutated in favor of opposite party number 7. Paragraph. However, when the government filed an appeal against the ex parte decree, that too was dismissed in default. Paragraph. Notwithstanding the above proceedings, if the petitioners are aggrieved by the grant of mutation in favor of opposite party number 7, by way of the order of the Tahsildar, dated
Tahsildar order date.
it will be open to the petitioners to file an appropriate appeal before the sub-collector. Jaleshwar, is it?
No, Baleshwar.
Baleshwar. In accordance with law.
Yes.
Granting the petitioners that liberty the petitioners disposed of. All right. Right, sir. Good afternoon, sir.
Supplementary list for admission item number 1. RVWPET 10 of 2022.
May I please, Your Lordship?
Yes.
Your Lordship will kindly recollect, this reviewers filed those apprehensions with regard to that laying of pipeline, which is not adherence to the safety measures.
Correct.
And therefore, Your Lordship have been pleased to pass orders from time to time to produce materials. On the last occasion, Your Lordship was pleased to direct that both the parties also should produce video clips.
Yes.
For Your Lordship's appreciation, which has been produced before the court master of reasonable court. Apart from that, with Your Lordship's kind.
Yeah, 1 minute. 1 minute.
Before the clip is shown, may I just point out 2-3 aspects so that Your Lordship will be able to appreciate the video clips?
Yes.
In fact, they initially acquired a right of user of 20 meters. So that is possibly the safety measure that is required. And subsequently finding that there is no space like that, they reduced it to 8 meters. I think that is the admitted position, subject to my friend appearing for Gail. If I am incorrect on facts, he can correct me. Then when I file an affidavit saying that no, it has been reduced to 6 meters because there is no area, and they have said, yes, it is 6 to 8 meters. So that is how it has been scaled out so far as the width of the area is concerned. Now, on the last occasion when the matter was heard, I had demonstrated to Your Lordship from record that the safety measure, my lord, is minimum 15 meters on either side, and no piling, no construction shall be allowed. Though fact remains that one of the petitioner had made construction of the house, other have not made. The proposed site is for a residential zone and it is for construction only. Others will have to make construction. And in view of the safety measures they have adopted, namely that 15 meters of either of the side of the pipeline, no construction, no piling can be done. Our land also gets merged with the very zone itself, because it is only total 6 meters. Apart from that, they said that we are doing it 2 meters below and having this concrete cover and everything. I had filed an affidavit saying that they are not doing that. In fact, it is less than 2 meters at some point of time. I have stated on affidavit. My friend on the last occasion filed a memo by giving a drawing saying that it is 2 meters including the pipe. Now that is to be seen. In fact, I have filed an affidavit. If a commissioner also goes and digs, you will find that it is not 2 meters. Because at the time of laying, these petitioners being the landowners were there and they have seen it. Now that it has been covered. Now Your Lordship will see the video clips, so that Your Lordship will consider this aspect of my submission, subject to what my friend will say for the other side.
of entire length
Vapatra may not
of the
proceed.
internal road
Yes, it is there.
we are venture
Screen shared for everyone.
through which
That separate
the
pen drive was
12-inch
given.
I can
high
see it.
pressure transmission gas pipeline
This your lordship
is
can
routed
appreciate this will
by
never be either
GAIL
20
India
meters or
Limited.
anything. This is 6 meters.
The width of this internal road is only 6 meters.
And beneath this road, they are laying the pipeline both sides.
Pipeline
Your
is
lordship will see
routed
the
in
residential
the center
plots.
of this road, giving clearance to the plots of both sides. Only 6. There are total 7 to 8 bends throughout the length of the pipeline within this internal load. The depth of the pipeline from ground level measured while routing was only 1.7 meter, not 2 meter.
This is
as
your
per the
video clip.
affidavit
My lord.
submitted by GAIL India Limited. Further, a specific measure, there is no RCC slab cover or any protective cover given to the pipeline for the safety of locality, whereas 300 cover should be given all around the pipeline as per para 4.2
No, but that we won't know till we actually
of
dig up the pipe. We won't know if
petroleum
there's a
and
flap.
natural safety
My lord.
standards.
So how do you know if there's a flap or not?
My lord, that is on
Sir,
affidavit.
this is
by
a
me.
short video clip of entire length of the internal road.
No, but even for you
of
to assert there is no
venture
flap.
My lord,
through
in
which
fact,
the 12-inch high
my
pressure
lord, after the video is over,
transmission
I'll assist
gas
your
pipe.
lordship. Then I think there are 2 other videos.
One more video.
This is from the top.
Video clip has been prepared on behalf of review petitioners of OMBR for exact location of the pipeline. This is the aerial view of OMBR residential project taken from heights. The boundary outline of OMBR project surrounded by cultivation land can be seen. Touching the boundary at north side, 180-feet wall canal is passing can be seen. The internal roads are developed by the builder to give access to the plot owners and incumbents of the venture. It can be seen many buildings have been constructed and the society is also developing. However, GAIL have already routed the 12-inch high pressure transmission gas pipeline under the internal roads of the society, by which approximately 60 to 70 plots are falling under hazardous zone. The line is not low pressure distribution line, so it deals very high pressure. It can be seen many bend points have come up while routing the pipeline. The line routed under the internal road, in fact, is not at 2-meter depth as for affidavit submitted by GAIL, but it is only 1.7 meter, which can be verified. Further, at specific measure, it can be seen that no RCC slab cover or any protective cover given to the pipeline for the safety, whereas 300-meter cover should be given all around the pipeline as per para 4.2.5 of schedule 1D to petroleum and natural safety standards. However, the petitioners have been proposing to divert pipeline through the available route in cultivation land and other side of 80
No, but
feet. Feet.
'isn't the gas
Canal, as
supposed to
shown
supply to all the households?
No, it is they are taking the gas. It is not for supply to the households. Subject to.
It's not for supply to the households.
Not to these households.
Yes.
It is actually a part of 100-kilometer pipeline which originates from Jajpur.
Why do you want to go through the village, through the colony then?
Pardon, my lord.
Why don't you look at that alternative which is along the canal?
My lord would have seen from the video clip that most of it was cultivated land. Even the plots now, which in respect of which.
See, the point is now there are residential complexes there.
My lord, when the notification was issued, at that time most of this was an agricultural land. This was agricultural land when the notification was issued. My lord, subsequently the grievance of the petitioners in the writ petition was that their homestead land should not be used for laying of pipeline. My lord, against that there was a concession made and the pipeline was realigned through the internal road. And my lords had passed the order dated 15th December 2021. Thereafter, this review petition was filed. On 15th December 21, the writ petition disposed of. On 24th or 27th, the review petition was filed. Within that period, the pipelines were laid, my lord. The review petition was disposed, the writ petitions were disposed of on the ground that GAIL will adhere to the safety regulations of 2016, 4.2.5, Schedule 1D.
Correct.
Then, my lord, in this review petition, my lords had passed the order dated 11th March, pursuant to which these video clips have been filed. And
Justice Mahapatra,
yes, sir.
I have a meeting at 1:45.
So we'll continue.
So, can we have it on some other day?
8.
We have to sit at 4 o'clock on some day because this is going to take longer than I anticipated.
Man.
8th July, Friday, 4 o'clock.
Oh, can we sit on Thursday? Because next Friday is a holiday.
Next Friday is holiday.
So next Thursday at 4 o'clock. 30th, on 30th at 4 o'clock.
Man.
Okay.
May I take back and produce it again, or it will be with your lordship's court master?
No, it will remain here. You said the two video clips have been viewed in the court. As the arguments might take a longer while, list on at 4 p.m. on Thursday 30th.
Obliged.
Item number 2.
Yes.
My lord,
I am
the
for-
last
I am
order,
for the opposite.
your lordship has directed me to obtain instruction that so far as the petitioner's vendor's lease is concerned, what is the status? Whether it actually, what has happened so far as petitioner's vendor's lease is concerned? Initially, a suo motu proceeding under section 7A3 was initiated for cancellation of that lease. That proceeding was dismissed by the collector, the then collector. So lease remained. That order of the collector was challenged in the High Court, and yesterday this Honorable Court Justice Biswajit Mohanty, and I have filed the writ petition both, has admitted the case and stayed the order of the collector.
My lord, my property is Titivan.
No, it is Titivan. Later it was converted to Titivan, but no, I have given the writ petition copy to your lordship.
I am purchased my salary.
Why don't you go through the writ petition?
He has purchased from the original lessor. I don't, but he is vendor who is the original lessor, lessee. His lease was the cancellation of his lease of the particular Moja, because by virtue of a court's order, there was a crime branch inquiry and it was found that there was some illegality or whatever.
Original lease is passed out.
Yeah, against him the writ is not passed out. His legal heirs are impleaded as opposite party. I am giving the copies of the writ petition.
I am purchased the land 1993.
So let's see what the writ petition says, sir.
And one thing I want to submit to your lordship.
Taking
so far as the land in respect of this Mauda is concerned,
go through this. You said that writ petition civil 14454 of 2022.
Yesterday, the
state of Orissa versus Uchab Balakantra and others.
Yes, your land
was listed before this court.
Yesterday,
before the bench of Honorable Justice B. Mohanty and B.P. Satpathy.
Yes, Ratho.
And S. Ratho J. and notice has been issued in the said petition. And an interim order has been passed.
Yes,
Staying an order dated 18 July 2003.
of the collector.
Passed by the collector Khurda in revision case number 32 of 1997.
Perfect.
Arising out of WL case number 228 of 1984 under section 7 capital A of the OJLS Act.
My lord, I am not the party.
The subject matter of the said petition is this very land which is the subject matter of the present review petition. Copy of the writ petition and the order passed thereon be served upon counsel for the opposite party in the review petition.
What I beg to submit, 1 minute. In respect of this particular Mahuja, we have filed 23 writ petition challenging the lease order. And some ancillary matters are also pending, and in all the cases, the orders are passed. They put up this matter after disposal of this writ petition.
My lord, my plot is not a lease plot. My
No,
plot is PT1.
Your
That was subsequently converted.
Yes,
No,
yes.
no,
Your
no,
vendor
before
was the lease.
purchase-
Your vendor was the
Before
lease.
purchase,
I don't say that.
it was PT1.
Anyway,
Yes, my sale deed is.
when is the writ petition coming up?
Next
Yes.
month. Next month, date is not
You say list this review petition.
after disposal of this.
Yeah, no,
My lord, my-
on a date on 2nd September 2020.
My lord, my sale deed, please.
You go through it, sir. You go through it. All right.
My lord, one single bench, if you outright matter, my lord, interim order expire on 27th, my lord. This matter may be listed on 27th, my lord.
I don't understand.
A single bench matter.